Bring this meeting to order. Good evening. Today is February 15th, 2023. Welcome to the Town of Woodfin Board of Adjustment Special Meeting. At this time, I would like to call to order the resumption of the administrative appeal of Jessica and Alex Bernstein and the Citizens for Responsible Land Use from the determination of Sharon Tuck, interim planning director, contained in a letter dated September 30th, 2022, concerning the Robin Hood Road development application. I would now like to take roll to certify this board quorum. Mr. Hanson.
Here.
Ms. Gosnell.
Here.
Myself, Michael Bennett. Ms. Hoffman.
Yeah.
Mr. Deroni.
Here.
Okay, then I'd like to turn this over at this point. Oh, first, a couple quick notes. This meeting will recess at 9 p.m. as close as possible, that we can find a good place. We will also take about a 20-minute break at a good point around 7 p.m., just so everybody's aware of that. And I'd like to turn this over to Mr. Golden, please.
Thank you, Chairman. As board members, as we had previously discussed and went through at the beginning of the hearing when we talked about ethical considerations, in an effort to assure or assuage any concerns that I may have had, I want to today go through some additional questions individually with each member of the board to ask about those ethical questions. And I'm doing it based on information that I've heard and some questions that have been asked by our board members to the witnesses. And so when I do that, I'll ask each one of you specific ethical questions. We'll go through the whole lot of you. And then, as permitted, we will allow each one of the attorneys for the parties, that's going to include Mr. Henning, Mr. Knorr, Mr. Portnoy, and Mr. Swords, the opportunity to ask the board any questions. And the reason that we're doing this, I want to run through real quick 160D, 109. And I think we started with that at the very beginning, if you all remember, when we were talking about ethical considerations. I'll read it to you again. 160D 109 in dealing with quasi-judicial decisions says, a member of any board exercising quasi-judicial functions pursuant to this chapter shall not participate in or vote on any quasi-judicial matter in a manner that would violate affected person's constitutional right to an impartial decision maker. So again, we all have to be impartial. I'll ask some questions about that. Impermissible violations of due process include, but are not limited to, a member having a fixed opinion. I will ask about fixed opinions. Undisclosed ex parte communications. I'll ask about that. We've spoken at length about the close familial, business, and other associational relationships with affected persons or financial interest in the outcome of this matter. As a result of those questions, which I will get to in a minute, if there is an objection raised by any one of the attorneys for the parties as to a board member's participation at this hearing, and that member, after consideration and objection, decides not to recuse him or herself, the remaining members of the board shall, by majority vote, rule on the objection. And so all of that is to say, if after my questions, and we open it up to the attorneys for the parties, if there is an objection to any one of the members participating in this matter, if that member says, no, I don't think I need to recuse myself because I don't have a fixed opinion or bias, then the board is, as required by statute, the board must take that vote up by a majority vote, which goes to say that if one member, if we're voting on, out of a 5-member board, if one member can't vote on their own recusal, and it's 4 members, a majority vote would be 3 out of the 4, because 2 out of the 4, my math is bad, but 2 out of 4, it's not a majority. So it'd be 3 out of the 4. And so what I want to do is just run through. We have talked about being an impartial decision maker. Mr. Hanson, I want to ask you a couple of questions. Throughout this whole process, have you paid attention to the evidence, and do you think that you can be fair and impartial in applying that evidence or the facts that you've heard to your determination of the issue in this matter?
Yes, sir.
Have you conducted any independent investigations or outside research which has potentially could have an influence on your ability to make an impartial decision?
No, sir.
Have you had any ex parte communications? And ex parte communications can be defined as a lot of things, but ex parte communications can be communications with board members meeting with the developer, a board member taking a call for a neighbor, or board member communication amongst themselves in which they deliberate the merits of the upcoming application. Have you had any ex parte communications? And I will say this, you say no, which is fine. It's not impermissible to have those ex parte communications, but you have to disclose them if you have had them, because what is impermissible is undisclosed ex parte communication. So if you've had any, please disclose them, and if you haven't, say no.
Ask the question one more time.
Have you had any ex parte communications with anybody involved in this case? That means anybody that's a party to the proceeding, any member of the public, or any other board members, which could be considered deliberations in this matter.
No, sir.
So you think that you can be fair and impartial, you don't have a fixed opinion about this matter, and realize you haven't heard all of the evidence. So you can still be open-minded, fair, and impartial.
Absolutely.
All right. Ms. Gosnell, the same questions to you, and I basically forgot where I had started, but can you be an impartial decision maker in this matter, listening to all of the evidence, applying the evidence as you recall it to the way you interpret the ordinance to come to a result in this matter?
Yes.
Have you done any outside research or independent investigation that had or that could have had an influence on the way you might decide this case?
No, I haven't even opened my books when I leave here.
Good for you. I mean, that is good for you. So do you have a fixed opinion not susceptible to change?
I do not have a fixed opinion.
Have you had any ex parte communications with anybody that's a party to this action, any outside parties, any witnesses or other board members, such that you could be deemed to be deliberating the facts of this case before such time?
No.
All right. Anything else you want to offer? Nope, you all good?
Yeah.
All right. Mr. Bennett, same questions that I'm going to ask you about being an impartial decision maker. Can you be fair and impartial and give each side an opportunity to present their case?
Yes, sir.
You can listen to the evidence as presented, then apply it to the way that you would interpret the provision of the ordinance so that you can come to a conclusion in this matter.
Yes, sir.
Do you have a fixed opinion not susceptible to change at this point?
No, sir.
Have you had any, have you done any independent investigation, outside research that could or has had an influence about how you are going to rule in this matter?
Can you repeat that? No, I have not. Sorry. No, I have not.
That was excellent. It got me off track. Undisclosed. Have you had any ex parte communications with parties to the case, witnesses, outside individuals, or board members such that you could be deemed to have deliberated the case before an appropriate time?
Absolutely none.
Okay. Anything else you need to add?
No, thank you.
Ms. Hoffman, and I hate to say it, there was a question that you asked and some information that you disclosed that said you have done some outside investigation and independent research. Now, just before we get into the questions, I want to know, from what you said, all I recall is that it was research into a dictionary. Is there, can you tell us and put on the record what, in fact, you did and what you looked up?
Sure. I looked up because we had talked all the time about the
dwelling.
No, the dictionary.
Oh, Planner's
The
Dictionary.
Planner's Dictionary.
Okay.
And I decided to look at a dictionary to see what the definition of dwelling was. And it didn't influence me in any way. I just wanted some clarification because it seems as though all we ever did was talk about the Planner's Dictionary, and I thought, well, there are other dictionaries, so that's why I looked it up. But, it didn't affect me in any way or change anything, about the way I think about the case.
Okay, and I'll start again. So, do you believe you can be an impartial decision maker, listen to the ongoing evidence that is presented, and apply the facts as you recall them to the way that you interpret the zoning ordinance so that you can come up with a decision in this matter?
I do, I feel that way.
And do you have a fixed opinion in this case as of today that is not susceptible to change?
No.
And so then we already talked about the outside investigation or the independent research. Is there anything else? And I'll ask some of these questions. Is there any other independent investigation, outside research that you did outside of looking at a dictionary and the definition of dwelling that may influence or could have an influence over your decision in this matter? And if you need to, please tell everybody.
No, I haven't looked anywhere else.
Okay.
This is enough.
Yeah. I understand. And so based on that research that you did, did it cause you to have a fixed opinion about any aspect of what you will be tasked with doing as a board member in this appeal?
No, it didn't.
Have you had any ex parte communications with any parties, outside individuals, or board members that such communications could be deemed deliberation before such time? And what I mean by that is, even if you, on a hot mic moment, maybe had a correspondence or a communication with somebody, again, it's not that you had the conversation, it's that you failed to disclose it. And so I'm asking you if you've had any ex parte communications that you think might be considered deliberations, such that you need to disclose that to this board.
No.
And then we already talked about the close familial ties and the family relations. So you think that you can be fair and impartial, and nothing that you've done, the independent investigation, has influenced your decision as we sit here today?
No, nothing.
All right. And Chris, I'm going to call you Chris because I forget your last name, or I can't pronounce your last name.
Duroni.
Duroni.
Either is fine.
Yeah, perfect. Impartial decision maker. Are you going to be able to be an impartial decision maker, listen to the facts as they are presented, apply those facts to the ordinance as you interpret it so that you can come to a just resolution of the case before this board?
Yes.
All right. Do you have a fixed opinion in this matter that's not susceptible to change?
No.
Have you done any independent investigation or outside research which has had or could have an influence on how you would rule in this matter?
I have not, but I did drive by the site. Is that okay?
Yeah,
That's
no,
okay.
that's fine. I think you disclose that every day, every time of the meetings.
All right. Just making
And that's
sure.
fine. Nothing that you saw, you didn't talk to anybody when you drove by the site?
No.
Nothing that you saw as you approached the site outside of the site itself has caused you to be less than fair or impartial?
No.
All right. Ex parte communications. Again, ex parte communications are communications with the parties, anybody outside, any witnesses, or potential board members that could be deemed to be considered deliberations prior to the appropriate time. Have you had any of those?
I have, so I'll disclose this because this was not something that was this happened within the last week.
Okay.
There was a person that I didn't know at the Woodfin YMCA that recognized me from being on the board and asked if they had any way that they could write a letter of opinion to express their opinion about the case, and I told them I don't know what the process is, and that they should contact the town of Woodfin if they wanted to get any information added to the case or anything that I didn't know what the process for that was. But so I just want to make sure that was disclosed.
Yeah, no,
I was
absolutely.
letting her know that I didn't really know the process for dealing with adding new information into the case, and figure I should disclose that because it was in a public place and anyone could have seen us talking.
Yeah.
And wondered why are they talking about the.
Right. Well, even outside of that, if it was have you had any ex parte communications in a private place that maybe
No.
somebody hadn't seen you? All right. As a result of that conversation that you had with that individual at the YMCA, has it persuaded you one way or the other to rule a certain way, or has it influenced your decision up to this point so far?
No.
Okay. And the reason I ask these questions, of course, is it's important, right? The statute and the Constitution of North Carolina requires that all parties in a quasi-judicial hearing have the right to be adjudged by an impartial decision maker. Thus, a board member who is biased or has a conflict of interest must not participate. We have gone through what biased is, having the fixed opinion. So if a dispute arises as to whether or not a member should be recused, the remainder of the board votes to determine if that member is to be recused. And where that comes from is 160D 109 in paren E. It says, and may have already read this, if an objection is raised to a board member's participation at the hearing, and the board member does not recuse him or herself, the remaining members of the board shall, by majority vote, rule on the objection. And what I wanted to do is I've just pulled some additional information that talks about these ex parte communications. It's important to disclose those for several reasons. The first is if you have those communications, it may be seen as you're showing unfairness to one side, that you're not being impartial. The second is that each one of the parties needs a quality decision maker, and if you are influenced by outside influences, you might not have the quality to be a fair and impartial decision maker. The third is bias, right? That you have this impartial or this impartiality one way or the other. And so basically, notably, the concerns of ex parte communications is a concern about the communications with the decision maker that is you that we need to disclose. And so now what we'll do based on this, and it may take a while, it may take 5 minutes, is that I'm going to open it up to each one of the board, or strike that each one of the parties to ask you questions. This is not, after the hearing last week, this is not their idea. I reached out to each one of them and said, in light of what I heard, I wanted them to have an opportunity to question each one of you all. So they may question all of you, they may question none of you, I don't know. But some of the questions that they may ask is about any discussions of facts, issues, or pieces of evidence presented as part of this appeal. They may ask you about the development project and whether you have a fixed opinion about the development project. They may ask if you've done any independent investigations about any facts, issues, or pieces of evidence presented as part of this appeal, or whether you've done any independent investigation as part of the development project. I think if those questions are asked, you can answer them. Remember, we're here on the appeal of Ms. Tuck's administrative decision related to the questions that were asked and Mr. Knorr presented in his closing. And so there may be some some hard questions. Again, please don't hold that against either party. This was my suggestion to let the parties have an opportunity to question you. We want to make sure that we are fair and impartial, don't have a fixed opinion, and any communications that we have had are disclosed, and give everyone an opportunity to consider recusal if they think it's necessary. So with that, I'm done, unless anybody has any questions of me. And I think we'll just go in the order of which the case has been presented, to start with Mr. Henning.
Mr. Chairman, the town does not have any questions.
Then it would go to Mr. Noor.
We don't have any questions, no concerns about the attendance of the board members this morning.
And although you all haven't heard from Mr. Portnoy and Mr. Swartz, their presentation will be today, I would ask them to ask any questions that they may have.
I do have a few questions. I want to acknowledge at the outset that, this is not something we want to do. This is an uncomfortable kind of situation for us to address, but it's something that we have to do at this stage. It's something we can't raise for the first time on appeal, so we have to do this now. And it is it's an important due process concern. So I do have at least one follow-up question for each of the board members, and then I have a couple of specific questions. So I'll just start at the end with Mr. Hanson. Have you made a site visit?
Yes, sir.
And why did you feel it was important to do that?
Mostly curiosity, so I understood what we were talking about.
And what did you learn from the site visit?
That it's a wooded lot, and there are roads that go up to it, and
That's
that's got a lay of the land.
That's fine. And I'll ask the same question, Ms. Gosnell.
Yes, I did. After our last meeting, I think someone here said that it was okay for us to do that, and so out of curiosity, I drove up there. Not sure if I was at the right place, but I did go to make a site visit.
And what did you learn from the site visit?
Same, it's roads, curvy roads up to the woods, and again, I'm not sure that I was at the right place. I didn't take any paperwork or anything with me. I was just heading home, and I thought I would check it out.
Mr. Bennett, same question.
I have not visited the site.
Ms. Hoffman, same question.
I attempted to visit the site, but I couldn't find it. I looked for the name of the street, but I didn't have any paperwork with me, and I wasn't sure exactly what the name of the road was. So I never found it.
And
I
what
do.
prompted you to make a site visit?
What prompted me, we got, all of us, I think, I don't know. I just decided I should get more information, so I tried to find it, and I didn't.
Okay. And when you say you wanted more information, what were you hoping to learn?
I was just trying to find, well, we had seen pictures and things of the location up on the screen, and I just wanted to actually locate it, just to find out where it was exactly. And I never did. Like I said, I never did.
Mr. Deroni, same question?
Yeah, I drove up there, and to answer the follow-up question, why?
Sure.
Same as you guys, really to learn about, kind of visualizing what we're discussing. It's hard for me, I kind of need to have the visual in my mind in order to understand the drawings that we're seeing, just to kind of piece the pieces of the puzzle together, really, to understand, the type of layout that the plans have with where Ms. Bernstein's property is located and things like that.
Okay, thank you. And then one more question down the line for the board. Mr. Hanson, have you expressed an opinion to any board member about what the outcome of this appeal should be?
No, sir.
Ms. Gosnell?
No.
Mr. Bennett?
No, sir.
Ms. Hoffman?
No.
Mr. Deroni? And I have a few kind of specific questions for Ms. Hoffman and Mr. Deroni. So, Ms. Hoffman, what have you discussed with your husband about this matter?
I didn't discuss anything with my husband about this matter because he doesn't care. What I discussed with him was attorneys and how there are 5 attorneys in this room right now. And I was more commenting on the process than, I never, he could care less. He just knows I go somewhere for 4 hours and, at the town hall, and he has no idea what we even discussed, no.
Amy, would you mind playing the clip from the first day?
What'd you say?
You could watch it on Facebook.
Yes, he could, but he doesn't care, he doesn't care.
And this is something that was brought to our attention by a Facebook commenter
Uh-huh.
on the Woodfin Facebook page. And you also get to see me enjoying a snack.
Oh, yeah. Looks. Hey, I just thought I'd give you a quick call. You took a little break. Man, oh my, this is going on and on. Lawyers are a pain in the ass. Oh, man. I had some questions and there weren't clarification questions. And you said, no, you know, the lawyer, I was going to ask the lawyer questions. Anyway, I just wanted to touch base with you and just hear your voice. Well, I can, but I can only ask questions of clarification because of our ultimate decision. And it has nothing to do with, well, if I ask a question like, is the planner proposing to do something? You know, that would be at another time. You know, I probably could ask that question, but not at this time, at this juncture, you know? Is everybody doing okay? Okay, sounds good. I just wanted to hear your voice. I'm not going to say I'm sorry that I am. You're just absolutely right, and I probably need to get more on an even keel. It has nothing to do anymore even with being in prison. It's more than that. It's being nasty, but and being nice, you know. Okay, I will have to see about something to work on that, okay? All right. Okay, so it looks like we'll be here until at least 9 o'clock. Oh, yeah. Is everything, you know, like it said, do you need me to do anything else? Oh, I'll be fine. Yeah, because when I get home, I'm gonna go to sleep in a short time, you know, even if I get home at 9. I wake up at 6:30 or 7 or something. That's more than enough time for me to get to school and everything, okay? Yeah, don't worry about that. I'm okay. All right, take care. I love you.
To get a date together. But I told Dan. You're gonna do what you're gonna do. Yeah, make sure that it's.
Okay, first, I just want to sympathize with the Ms. Hoffman from that date who was feeling that it was dragging on halfway through the first day,
Can I
and we are
interrupt
now
you?
on day 5.
Can I interrupt you? Exactly. I didn't think it was gonna go more than a day, and, yeah, so, exactly. Okay, go ahead.
But am I recalling this correctly, a few minutes ago, did you deny having ex parte communications about this matter?
Yeah, because I didn't discuss anything that He doesn't even know, my husband doesn't even know who the parties are. He doesn't even know what we're trying to decide here. I was just complaining to him about, and whatever it is I said, because he said to me, can you ask a question, or something to that effect. But there was nothing specific. There was nothing specific about what we talked about. He was trying to encourage me to ask a question.
And is this the only time you've talked to your husband about this matter?
Absolutely, absolutely.
Haven't even complained about it when you were at home?
No, he complains. No, I don't.
But you are, on that video, you are discussing a question that you wanted to ask, is that correct?
I said that I wanted to ask a question. I don't remember what the question was, but I said I wanted to ask a question. And I think it was about the protocol of when to ask that question and who to ask the question, the information, who to get the information from. That was what I was frustrated about and not clear about.
So I'll move on from this, and my next question for you and then for Mr. Deroni is, have you discussed any fact, issue, or piece of evidence presented as part of this appeal with any other board member when the full board was not present and in session?
No.
Mr. Deroni?
No, not that I can recall.
Amy, would you play the clip from day 4?
I still don't understand. I asked that question about this rezoning.
Yeah,
This really has was rezoning for the street.
yeah, that's a good point.
You know, it's the same day.
Okay, you know why? You know why? It's because they had an application.
Well, whatever the application was. Right, that's why they did it.
That's
And it would have been. Had that application not been there.
That's right.
And at this time, I don't think the technically was protocol.
Yeah, I agree. That's why they're eliminated, because they had an application.
It's really funny that,
Yeah,
that's the same day that they sent out the letter saying your thing expired, we're canceling it. So as soon as that was canceled, they said, let's rezone it.
serious.
No, they,
Whoa.
because they saw their mistakes.
You know, it's funny, most of this is, and we're not talking softball, but most of this is about dates and timings and signatures. You know, it's really interesting.
That we need to remember that.
Oh, yeah. Yep,
All of this stuff was just trying to get rid of the truth.
thank you. I agree.
No, that's
Yeah,
just
we're not talking.
but some of those things are all right.
So, following up on a couple of things that happened in that clip, Mr. Deroni, I'm not sure we can see the timestamp on here, but the timestamp is 2 hours, 31 minutes, and 48 seconds. It looked like you were writing something down and saying something like, I think that we need to remember that, and then you trail off. Do you remember what you wrote down?
I'd have to look and see, based on that conversation, exactly. I have a lot of notes. To be honest with you, I didn't know that we aren't allowed to kind of discuss all of the material, and I thought that I had said to the whole room in the past when I was asking questions that I'm trying to understand the timeline of all of these dates. In fact, I think I asked at one point, could we literally draw a timeline? So as I start to, I've got yellow sticky notes in here that are sitting here trying to take the whole RD book and put it into kind of sequential order, which subsequently, I don't know if this was on day 1, 2, or what, but in the closing, I think that Mr. Noor gave, he kind of helped clarify that even further. So this is before I really understood a lot of the timeline.
Can you look through your notes and figure out what you wrote at that moment?
I can look to see. I mean, I know that I was, from what I was recalling, I'm discussing around the July dates. Of the rezoning and the application. Yeah, so I don't have notes coordinated with, so the date that I was talking about was the July 8th cancellation, which I then realized was the same date that the July 8th rezoning letter was. So I don't have the notes that I wrote down about it, but that's what I was realizing as we were looking at those two dates.
But, so did you write something down at that time?
I don't know. I didn't on these pages, so I don't know if I had actually written something. I don't think so. I don't think I was taking notes at that point, because I usually write these during the meeting as people are talking.
So, starting at 2:31:48, can you get that close? Yeah,
2:31:48.
yeah.
So, I see it.
Which meeting date is this?
This was
It'll be on
last
minute
week.
So just to
15.
confirm, this was last Thursday night's meeting, correct?
Yes.
Okay, so.
This is last week's meeting? Okay. I'm trying to see which page that would be on my notes.
Maybe 2/3 or 3/4 of the way through, I think.
I still don't understand. When I asked that question about this rezoning,
Yeah,
everything else was rezoned except for those two.
yeah, that's a good point.
You know, it's the same day.
Okay, you know why? You know why? It's because they had an application.
Well, right, with the application. Right, that's why they did it.
That's
And it would have been, had that application not been there. And at this time, I don't think it was for the fall.
Yeah, I agree, that's why they're eliminated, because they had an application.
It's really funny that on July 8th,
Yeah,
that's the same day that they sent us the letter saying your thing expired, we're canceling it. So as soon as that was canceled, they said, let's rezone it. You know, because they saw their mistake.
well, it's funny, most of this is, and we're not talking shop, most of this is about dates and timings and signatures. You know, it's really interesting.
That we need to remember.
Hurry up. Yep,
All of this stuff is just trying to get rid of the truth.
thank you, I agree.
No, that's
Yeah,
just
we're not talking.
but some of those things are all right.
And I want to follow up on something you said. You said you didn't know you weren't supposed to. You know, I want to make it clear that I am not up here to morally chastise you for something you have done, okay? You all deserve all of our respect for your participation in this and your patience in this. So I just don't want you to think that I think you have done something morally wrong, you know? Were you able to see, while we watched that clip again, were you able to kind of remember what you were writing, or?
Yeah, I mean, I constantly, I mean, if you look at the way I do notes, I sometimes just go and like underline stuff, circle stuff, square stuff. I probably was just showing her these same things, and then, I don't know, I'm constantly just messing with my pen. I don't even think I wrote anything specific down then. I'm looking at, so, but yeah, so it wasn't any specific note that I wrote.
And this is a question for Mr. Golden.
I'm not under oath.
Well, do you know if the town has a system for keeping this, like notes and things like that, after these hearings?
I do not know if the town has a system for keeping notes that individuals make.
Okay. So, Ms. Hoffman, you, whatever it was, I believe you nodded and said, yep. Do you remember what?
I'm 75. I don't remember. I talk a lot, and I looked at what he had, but I have no idea what it was. I don't remember.
So moving to just a few seconds later, Mr. Duroni, you said all of this stuff is just trying to get around the truth. And my question is, and don't tell me what you think the truth is necessarily, because, but Ms. Hoffman at least seemed to understand what you mean by that. Have you discussed what you consider to be the truth with Ms. Hoffman?
Not aside from that conversation, no.
And Ms. Hoffman, without telling us what the truth is, do you think you understood what he meant when he said the truth?
I think we were talking about dates. That's what I think. I'm not sure. I'm really not sure. But whatever it was that he pointed to, I agree with. I don't know what it was. I don't remember what it was.
So when he said all of this was to get around the truth, do you think he was talking about the dates?
I have no idea. I don't know. I don't know. It was very confusing for us. It was really confusing. And that's why I think we were talking, just for clarification. We wanted to figure out what was going on, and we didn't understand it.
A few seconds later again, Ms. Hoffman, you say, yeah, we're not talking.
Right.
Who were you speaking to?
The rest of the board, I think. It was the rest of the board. I was just trying to assure everyone that we weren't talking about the case. And we didn't think we were talking about, I didn't think we were talking about the case, because we were confused. And we were looking to understand, not to make a decision, to understand what was going on.
So, but you were talking about the case, right? I just don't understand, you actually said it twice. Earlier, you said, we're not talking, and then the conversation happened, and then you said it again, we're not talking.
I have to say that I can separate, I am trying to separate, talking about the case from figuring out what the hell's going on. Okay, we didn't understand what was happening, and that's why we were talking. I guess we were talking about the case, but when I think of talking about the case, we think of influencing someone or making a decision of some kind. I'll speak for myself. I was really just trying to help him understand the question that he had asked me, and I don't remember what that question was.
Okay. If you don't mind, may I go speak with my client for just one moment?
And board members, just again, while Mr. Swartz is talking to his client, the process is contemplated under 160D 109 indicates that if an objection is raised to a board member's participation, it first goes to that board member to see if they can be fair and impartial and/or whether they should recuse themselves. But if they don't, if that particular board member doesn't, it automatically goes to the full board for a vote. But that's only if an objection is raised to a board member's participation at the hearing or prior to the hearing.
And can I make another comment?
Yeah.
Anything that I've been discussing up here, for one, I don't discuss it out of this room. I didn't realize that we weren't allowed to kind of compare notes and say like, hey, are you guys understanding this? Like, do we need to ask clarifications? Like, I thought that that's what we're supposed to be doing. I thought that we're supposed to be deciding as a board what this means and how to understand. I didn't know that I wasn't supposed to discuss it with her at all. So I wouldn't have been trying to draw, because I'm trying to draw conclusions. That's what my job is up here, is to make a decision based on all of these facts that are handed to me. And I didn't know that I wasn't supposed to be sharing my thought processes. And you're hearing, things that you're wondering, well, what am I writing down, and what was the specific thing that I'm saying that she agrees with? I haven't heard your side of the case yet. I'm waiting. I'm excited to learn, So as I get all this in, I didn't know that I wasn't supposed to be processing it with the board. So I apologize for kind of walking through some of my, understanding, and that seemed like the best time to do that is, hey, we're on a break, okay, let's go recap what we just learned.
And thank you for explaining that. That's insightful. Just wanted to make sure that now that we have a better understanding of ex parte communications, that we won't do it, but certainly we don't want to act as if we're deliberating prior to the time that we are set to deliberate.
Right, absolutely.
Okay. So, sorry, Mr. Swartz.
Yeah, and to follow up on that, Mr. Golden, you can probably provide a more thorough instruction, but, my understanding of the process is this is the board's decision to make. And that's why it's important that all of the board participate in any deliberations that go on.
Right.
Just to put it kind of in a basic way. So at this time, we are going to, I feel like I need to note an objection for the record to Mr. Garoni's conduct. However, we are not going to press for recusal of Mr. Garoni this time. We are, however, we are also going to object to Ms. Hoffman's continued participation in this and request that she recuse herself. And I have kind of a list of grounds that I'd like to state into the record. So first, we played the clip earlier of the phone call. So that clearly shows an ex parte communication between Ms. Hoffman and her husband. It is evidence that Ms. Hoffman is discussing this appeal with her husband, including what questions to ask. And it also shows, and I want to put this as respectfully as possible, Ms. Hoffman's lack of appreciation for the strict procedures required in a quasi-judicial hearing, which are crucial to ensure fairness to the parties and to protect the due process rights of the parties. In addition to the clip that we saw, there are at least a few other instances that we are basing this objection on. And I'll just kind of summarize them, and I won't make you sit through the clips or anything like that. So on day one, Ms. Hoffman answered in the negative 2 questions that I asked of CRLU's witness on traffic safety. And the questions and answers can be found on the January 25th transcript, starting at page 106, line 13, through page 107, line 5. On day 4, Ms. Hoffman let us know that she had done some independent research. She said, "I've looked at a couple of things at home, like dwelling. These statements can be found in the February 9th transcript, page 88, line 8 to page 89, line 4. Also on day 4, we saw the video of Ms. Hoffman deliberating the meaning of certain evidence with Mr. Deroni, and excluding other board members from discussion. So we saw, we're not talking. And that conversation starts at timestamp 2 hours, 30 minutes, and 25 seconds on the day 4 video. And since it occurred during a break, it's not on the transcript, so I don't have a transcript citation. These are a few examples that show evidence of a fixed opinion from day 1, and that show impermissible and improper communications. North Carolina courts hold that even one member of a quasi-judicial board, if even one member of a quasi-judicial board has a fixed opinion, the participation of that one member is a violation of due process. The communications with her husband about any of the issues in this case or what questions to ask are improper because he is not a member of the board, and not only is he not entitled to participate in the board's hearing, we don't know what input he had, so we can't respond to it or ask follow-up questions or anything like that. And independent research is a problem for the same reason. If we don't know what facts you have gathered, we can't address them. And finally, in that clip, we saw, deliberation of issues in this appeal are improper at this stage because not all of the evidence is even before this board. And as we just pointed out, the landowner has not even started its case in chief. So for these reasons, we object to Ms. Hoffman's continued participation, and we would ask that you recuse yourself.
I'd like to be heard on the objection before board member
I would-
ask some additional questions.
Absolutely, Mr. Henning, if you've got any,
No, sir.
Mr. Norm.
Just a couple things that I'd like to clarify, make sure I heard that right, heard things right, Ms. Hoffman. I think, one, I think it's been characterized as you all were deliberate. But I thought I heard you say that you weren't. Did I hear that correctly? And to be, I can.
Just for the value of those that are at home, I will ask that question again. I had heard that when you were answering some of Mr. Sword's questions, the characterization is that somehow you and Mr. Deroni have been deliberating, but I thought your testimony was that was not what you were doing. Is that correct?
That's correct.
Okay. And to be clear, have you done any deliberation with anyone about anything that you've heard in the case up to this point?
No.
Okay. I'll ask you the sort of same set of questions, Mr. Deroni. Did you consider or believe that anything you were discussing with Ms. Hoffman was deliberations?
No.
Okay. Have you made your mind up in any way? Again, I know you've answered this, but just to be clear, have you made your mind up in any way about anything you've heard in this case so far?
Not yet.
Okay. I think I also heard in the objection, Mr. Swords say that you excluded others from participating in that conversation. And I wanted to ask you first, Ms. Hoffman, were you excluding anyone from that conversation?
No, no.
And Mr. Deroni, were you?
I didn't intend it to be a conversation between two people at all.
I think if we're
Kinda
looking at the
open to-
clip here, weren't all the other board members sitting right just there at the,
I left and I came back to that spot while I looked.
okay.
Yeah, we can play that again if you like.
So, but to be clear, you all didn't try to exclude anyone, want anyone to be excluded, anything like that?
I did not.
Okay. Ms. Hoffman? One of the parts of the objection related to information, I think I'll back up. I'll start with call with your husband. I think the statute, 160D 109, says undisclosed ex parte communications. That conversation is disclosed at this point, correct? And I think you were asked questions about the contents of that conversation. Did I hear correctly that you've not discussed this case in any other way with your husband?
No.
Okay. As I was listening to the conversation, I heard you talking about it being a late night, correct? Okay. That you called to hear his voice. I know I do that in the break sometimes with my wife when we're having these late nights and just say, yes, I am coming home. But can you give a sense, what was this that kind of conversation? Was it a different kind of conversation? Were you just checking in at home? You know, what was going on?
Oh, I thought you were gonna speak. During breaks, when I'm in a meeting or just about anywhere, I call home just to make sure. My husband's not well, he's ill, and I need to make sure that he's okay. And so I call home pretty regularly when I have a break to just hear his voice and to make sure it's not only just for me to hear, for him to hear me, but I'm checking on him to make sure that he's all right.
Well, I'm sorry to hear that your husband is not well, and I appreciate you giving that answer. I also heard you talking about, you were saying you wanted to ask a question, and the attorneys weren't letting you, and not to pick on Mr. Goulden, but he and I are colleagues, but was there, I think, a particular attorney who cautioned you against the?
I don't remember.
Okay.
I honestly
Okay.
don't remember.
Probably him.
And that's okay, I'll take
That's all
that.
right. That's all right. And I think there was also in the objection a statement about what else you may have looked at and the inability to
Right.
understand what that is or, look into that. I think you'd said it was a dictionary, right? Was it Webster's? Was it?
I thought about that before I came here. It was a Webster's dictionary, and I wanted to make sure about that because I had a feeling you were going to ask me about that.
Okay.
Yeah, it was a Webster's dictionary.
Have you looked at anything else?
No.
Anything? Okay. I think those are my questions, and then I'd like to be heard. Well, I'll just stay here on the objection. So there are sort of three parts to that objection. One was based on the dictionary, one was based on the conversation with her husband, and one was based on excluding, I think, the others, the deliberation sort of aspect to that. The statute is clear. It talks about undisclosed ex parte communications. The communications have been disclosed. Everybody's had an opportunity to ask the member about the communication. I at least feel like I understand what it was, so I don't think that's a ground for disqualification. And due process works both ways. It's important that the board members who hear the evidence are able to make decisions based on the evidence because that's why the town appointed 5 people to this board and asked you all to do it. I know you are thanking them profusely right now for doing that to you.
Yeah.
But, we do want to make sure that people who have a fixed opinion aren't making decisions, but we don't want to disclose folks who are still listening to the evidence and trying to do the best they can from continuing to participate and to reach a decision. That's what provides due process for both sides. So I'll say that related to the conversation. Related to outside information, I think Ms. Hoffman, she said during the hearing last time, hey, I looked at a dictionary. She said it tonight. She's told us the dictionary. I think that keeps them from asking anything else about the dictionary, pulling that version of Webster's up, looking at the definition of dwelling, exploring that issue, and she says she's looked at nothing else. I don't think that's a basis for disqualification. It's certainly not an enumerated one under the statute. And then the deliberating and excluding others, it doesn't seem like the testimony, it's not even testimony, because y'all aren't under oath either. But it doesn't seem like anyone said they were doing that, they were making a decision, et cetera. It was, at least from my recollection, hey, I'm scratching my head about this thing here, and I'm trying to figure out what it means, and, maybe we'll get to it when we get back, and as I recall, I think Mr. Droney may have even asked some questions about that during that day. So I don't think this falls into the category of what the statute says is a disqualifying situation. We don't have members with predetermined minds. We have disclosed communications. I think everybody appears trying to do the best they can. You all are volunteers. You're not paid professionals. We appreciate the time that you spend on this, and I just don't think there's grounds for this. Instead, I think we should move to the rest of the evidence, let the developer put on their case, and let you all make a decision. So we don't think there's a basis for it. Thank you.
And Mr. Swartz, as the objecting party and the one carrying the burden for recusal, if you want to, and you're coming up here, but if you want to respond in any way.
Yeah, just real quick, and I meant to try to catch Mr. Norton before he sat down, because my client reminded me of another instance. It was at the end of day 4, timestamp on day 4 video at 3 hours, 22 minutes, and 20 seconds, and in February 9th transcript at page 137, line 18, Ms. Hoffman clapped at the close of Mr. Norr's argument. So I don't know if you want to address that at all.
Can I say why I clapped? Because it was over. It wasn't about what he said, it was that he was finally finished. That's the only reason I clapped. It wasn't a comment on what he said, it was that it was done.
At the risk of saying too much,
Sorry.
I would agree, but we admonished her for that too, I think, immediately after that was done.
Yes.
Yeah, sorry.
Combined with the other things, I think it is evidence that could show a fixed opinion from day 1. We heard about the answering the questions for the witness on day 1, and it's kind of bookended with the clapping at the end of day 4. So that's all I wanted to bring up about that. And in the interest of getting this over with, I do want to move on as quickly as possible, but I do want to make clear that this is not about what anyone intended to do. If you stated that you didn't intend to do anything impermissible, and I believe you. It's the fact that it occurred that's problematic. So you could be deliberating without realizing you're deliberating. That's still a problem because the whole board is not participating. You could be having an ex parte communication without realizing you're having an ex parte communication. But that's still problematic because this person is having input. And by the way, I think there's a distinction. Maybe Mr. Golden can, elaborate on this. But it's not the fact that the communication occurred that has to be disclosed. It's what was said, I believe, so that the board understands what occurred and what was said. That's what I think is the case. Maybe Mr. Golden can confirm or deny it.
Can I say something again? When I talk?
Yes, if you, absolutely. Now would be your opportunity.
How can I put this? I'm not happy with the fact that you have speculated that I have done things that I haven't done. And you have done that several times. About the phone conversation, even when we were talking, Chris and I were talking to each other, you're speculating that maybe that happened, but it didn't happen, okay? And it's not, and again, that's one of those things, I guess, that you try to say that it happened when it didn't happen. And you just want to it's hard for me to say this because I don't want to offend you, okay? But you have taken it upon yourself to speculate in a couple of different instances that there was intention and that there was something that was wrong that shouldn't have occurred. And I think that both myself and Chris have said that we didn't intend for any of this to happen, or for our conversation, and that we probably don't know enough about the process, and because we're townspeople, we don't know. I have never been in a courtroom, okay? I have, thank the Lord, I have never been in a courtroom. So I am not aware of what should and shouldn't be done. And so it's not like we knew it, and we did it anyway, that kind of thing. So I just want to be sure that when you say, like, again, for the phone conversation, that it could have occurred, but it didn't occur. My talking to my husband, like I said, bring him here and he will say he has no idea what's going on here. So, again, you're speculating that I have done something wrong, and I haven't.
And we don't need to go back and forth, so Mr. Swart, I'd ask you not to respond.
Yeah.
And Ms. Hoffman, what I would, I guess, say is that the objection's been raised, it's their burden to prove it, but anything that they raised was likely as a result of my conversations saying that I think I need to independently ask each one of the board members about all of the independent investigation, outside research, fixed opinion, influence. So you may not like the way that he did it. You can't hold it against his client. But what I'm saying is the reason for doing this today was precipitated by my belief that we needed to offer, we needed to show that we as board members, you as board members, didn't have a fixed opinion. And so if you are testifying here or saying to them today that you don't have a fixed opinion, that you haven't been influenced by anybody, and that all of ex parte communications that you have been disclosed, I think we should leave it there. There's no reason to, and certainly don't hold it, what Mr. Swartz is doing, it's his absolute right to do it, and he should do it. Don't hold it against him or his client.
Sure.
And so I guess the objection's been raised, and I'll move it along, Mr. Swartz. Thank you for letting me jump in. And Ms. Hoffman, it goes to you first. Do you feel to such an extent that you need to recuse yourself based on bias, which means you can't be an impartial decision maker, or that the research that you have done has influenced you to an extent that your mind is not susceptible to change? If you are in that position, you would need to recuse yourself. But if you think you can be fair and open and honest, call it like you see it, then you don't need to recuse yourself.
Okay. I don't want to recuse myself.
Okay, and with that, the way that the statute says, we're just going to put it up for a motion for the board. So the objection would be to have Ms. Hoffman, the objection was to have Ms. Hoffman continue as a board member. And so what we need to do is just poll is, I guess, would there be, the motion would be to have Ms. Hoffman recuse herself. So that would be the motion. So if someone can move that.
Do I hear a motion to see if Ms. Hoffman should recuse herself?
If nobody makes the motion, or do we?
If you need to make the motion,
To
and then
vote
you
on
can,
it? To vote on it.
and then to vote on it, yeah.
So is it the motion to vote, or is the?
The motion would be to vote on having Ms. Hoffman recused from further participation in the board, or in this determination.
And may I ask a question before we do that? First of all, am I allowed to make a motion, or I'm not supposed to make motions?
You can make a motion.
Okay, number two, are we supposed to, or should we have any discussion in this matter, or we should just vote on this matter?
Yeah, you should have discussion on it if you want to.
Discussion, not closed.
After you make the motion, you can have discussion on it.
Okay. So do I have a motion from someone to vote on whether Ms. Hoffman should recuse herself,
I so move.
and I'll second it.
Now the board can have discussions if they want to, if not, we'll call a
Would we
vote.
like to, does anybody have some discussions on this before we vote? I'm asking the board.
I was making notes on what his specific objections were, and I'm in agreement with some of the comments that Mr. Noor made. You know, the conversations with her husband, for example, were about the process and not the case. So I think, I don't think that the things that he's objecting to are really detrimental to the case itself or her ability to make a decision about it.
I don't think up to this point she meant any harm or didn't think she was doing anything wrong, but I think now she's upset with the fact that she's being asked to recuse herself, and
Do you feel that?
that
could
might make. that-
Sway her vote?
Yeah, I think that could.
Okay. Vice Chairman Hanson, do you have any?
I think actions, I think, based on what we've come to understand in the process, actions were careless. And I'm hearing from you that you did not know process and that things you would change in the future, and change in the past if you could, but cannot. Would you believe in any way that you can't be,
Not at all. As a matter of fact, we haven't even heard the other side of it. So I'm kind of thinking, right now, it's only half done, you know, and I'd like to hear the other side of it. I haven't made any decisions at all, nothing.
All right. I'd say, so my comment is, I've been on various boards for over 30 years. Recreational advisory boards, planning boards, zoning boards, joint land use boards, multiple boards. And I have to say that this is the first time that I have ever had to sit in on an appeal. So I have to say, common practice, due process, I'm not sure. I am not familiar with the way it goes. So I think that everyone on this board is probably in the same boat. I also have to say that me personally, and I believe everybody else, I don't know that any of us have known each other prior to this board sitting starting last year. And I don't know anyone outside of here. I mean, I met Mr. Hanson, I think, at a CVS one day and said hello, and that's about as it goes. That's as far as it goes. So have unintentional errors in due process been done? Based upon what I'm hearing, I have to possibly agree with that. But we have also come forward and made all this information public to everyone, and we have, and I forget the legal term, we have everybody made aware of it now.
Disclosed.
We disclosed all the information. But we're all learning here. I mean, we don't know the process. So this is a learning curve for all of us. You know, mentioned, our volunteers, we're new at this, and I have a lot of experience, but not in this actual appeal thing. So that being said, I wanted to get that out. Any more comments or questions? Ms. Hoffman, do you have anything else you want to say before we take a vote?
I think I've said it.
Okay, Ms. Hoffman does not vote.
Does not vote.
No.
Right.
Okay, so I'm going to poll one by one. if that's
Sure,
okay.
that's fair.
Vice Chair Hanson, Mr. Hanson?
So the motion is to recuse her, so that's, we'll make sure we're
So
voting on
we
it.
are asking, a yes vote would be to recuse Ms. Hoffman.
Correct.
No. Ms. Gosnell?
No.
Okay, Mr. Deroni?
No.
Okay, and I will vote no. So that being said, then we are not asking, so I guess your motion is, or your objection is overruled?
Sure.
Thank you.
And, go ahead, Mr. Noor.
I was just gonna say, whenever you have a moment, a 5-minute recess or after break would be appreciated.
I was just gonna say, since we just finished this up, it would probably be a good time to take a 5-minute break, because I think what we're ready for, Mr. Portnoy, is maybe your case in chief? Yeah.
All right,
So if we could take just a couple minute
Just take
breaks.
a
so-
short break, and we're still trying to plan something around 7-ish, a little bit longer for a few breaks. but-
Wait, but even just short.
That's fine. Let's recess until 6:25 by that clock in the back room, please.
I'm sorry.
So let's leave this table.
Do you want the little side table? I was using it.
No, I can, yeah, do it from here.
Sure.
Yeah.
If you're not in here. Oh, hot mics?
Yeah, just so we're on the same page. Sorry.
I've heard good things about you from my friend Sam Craig. He doesn't know that you would say nice things about him, but he says I think I'm a thorn in his side on a regular basis.
He and I sport a little bit. This matter's still going on, by the way.
Is that you digging for trash? Is that what you're?
No, I have some snacks in here.
Oh, nice.
But you know what? Would you bring me a water?
I will. I certainly will.
I want to take this one. This one.
You wanna take that?
No,
Take it.
let him bring it
Okay.
more because they had big gigantic water bottles, so they're set, but, you know.
But I'll tell you, all that he's drinking is maybe run this bathroom.
Yes, I went out this morning, and this is what I have left over. It was in my car, I think I better put it in there.
Yeah, I have one in my car too, I should have brought it in.
I usually have, like, Cheetos here.
Yeah. I never think about that.
It pays off to have extra water.
It really does, but like I said, then you've gotta go to the bathroom all the time.
That's right.
We'll get you some. They're getting you some. No.
Okay.
Here.
Yeah.
That was mine. You can have it. I brought my own.
Yeah.
Okay, I'll take it.
Have it.
You can turn it down. Just letting everybody know I'm turning it down. And just get your winter coats out for a minute, okay?
Yeah.
Just in case you need some water. Water.
Oh.
It's another. That's not
I thought you
coffee.
were bringing me some coffee.
Yeah, but that's water. Yeah.
I'll take it.
Water too. Yeah.
It's down, Jesse. I'm putting this box on the back here. Will be good.
Just a quick repetition of things in the last few weeks.
But you haven't gotten it yet? It's been so long. I know my wife is going to be like, it's a long night. Yeah, I've been we have meetings for other projects, so I've been
Oh, okay. Nice. Are you staying or are you going home tonight?
staying again. Yeah.
One, two, Mr. Portnoy. Okay. Okay, let's call this meeting back to order. I would like to remind everybody, if you haven't already, check your phones and make sure they're on vibrate, so we don't have any issues tonight. I believe that we're ready to go. Mr. Portnoy is going to start giving your side of the case. Is that the correct way of wording it?
Correct, yeah. And I'm going to start with a brief opening, and I again want to thank you all for the time you've put into this. Like many of you, this is a first for me to do this in North Carolina, as you know. We came in, again, having 3 days set aside, thinking maybe it will be one, maybe two, at most three. We're now on day 5, I believe. My wife is watching, so she at least gets some alternative to usually what she sees on, Thursday night or Wednesday night TV. So that's the benefit. But I appreciate you all being here on day 5 and sitting through this. And we are excited, I think, right now to have that opportunity to tell our side of the story. There's been a lot that's been said so far as to what the potential meaning of the emails or communications from Chris Day mean. You're going to get the opportunity to hear from Mr. Day himself. There's been a lot of speculation and conjecture on what certain documents in the record mean, but what you haven't heard so far yet is what went on behind the scenes. What were the communications between the town and HS Robin Hood that you can't get from the record of decision? What you're also going to hear about is what was going on internally at HS Robin Hood, why these alternative site plans were provided, what was the reasoning of those. But before we get into that, I thought it would be helpful to remind the board why we're here, what we've heard so far, and what you're about to hear. Why we're here. We're here because the petitioners have appealed a September 30th, 2022 determination made by Ms. Tuck in her capacity as the interim planning director and zoning administrator. What's critical about this is it's actually a very narrow determination. You've heard a lot of information so far, but a lot of that falls actually outside of what Ms. Tuck determined. Ms. Tuck's determinations are fairly straightforward. One, a revised site plan that consolidates all of the residential units and amenity areas into a single building would not be defined as a group development. It would instead be classified as a multifamily building. 2, as a multifamily building, the use is classified as a permitted use, provided all other technical standards are satisfied, i.e. height does not exceed 35 feet. And 3, the review of the revised site plan would be ministerial in nature and would be based on the rules in place at the time of the application. Things that aren't in here are equally important. What's not at issue is whether or not the October 18th, 2022 site plan depicts a single building. Now, you've heard a lot of evidence on that issue, so we're going to address it. But I just want to remind the board, these are the 3 issues that are actually up on appeal. So, what are the petitioner's arguments in response? There's 4. The first is that the old rules don't apply because the May 17th, 2021 application was not legally submitted. 2, that the old rules don't apply because HS Robin Hood did not adequately respond to the questions from Ms. Eisenhower. 3, the old rules don't apply because HS Robin Hood, through the email from Chris Day, placed the application on hold for a period of 6 months. And then 4, this is where it gets into arguments that are actually outside of Ms. Tuck's September 30th determination, relate to the October 18th site plan, which did not even actually exist at the time Ms. Tuck made her determination. It's also important for you to remember the burden of proof. The burden of proof on this case falls on the petitioners because they are the ones that are appealing the determination made by Ms. Tuck. So it's important to remember that as you start to hear the additional facts that we're going to tell you through our side of the story. So let's talk about what their arguments are, though, very briefly, to see what we've heard today. The first argument was that the application was not legally submitted. But it's important to remember what Ms. Eisenhower testified to on that fact. There we go. Ms. Eisenhower, did you consider the application submitted as of May 17th, 2021?
Yes, I considered it a complete application.
So that was her testimony. Yes, I considered it a complete application. In response, the petitioners say, well, it's incomplete for 4 reasons. The site plan didn't have the dimensions of the building. The site plan did not have design guidelines. The application did not include sewer and sanitary approvals. And the site plan did not include a landscape compliance plan. You're going to hear why their reliance on those is misplaced because they're based on inaccurate interpretations of the ordinances that they're relying on. But at the same time, there are situations where those same standards are actually met and exceeded. One of which actually is the first argument they make. The dimensions were not there. But one thing that Mr. Green failed to testify on, and you're going to hear about here, is that every single site plan had a graphic scale and was drawn to scale. So the dimensions were available and accessible. You also heard Mr. Green talk about the building design guidelines. You're going to hear why that does not apply, though, at the time a zoning compliance permit application is submitted. But nonetheless, you also did not hear Mr. Green testify to the fact that those very guidelines are actually noted on every single site plan, starting with the May site plan, all the way through the October 2022 site plan. Mr. Green also talked about why sewer and water permits were required at the time of a zoning compliance permit application submission. You're going to hear why that opinion is incorrect. But nonetheless, you're also going to hear why the reliance of Mr. Green on those certain ordinances is misplaced. In one instance, this was pulled directly from Mr. Green's report. You noted that there's an ellipses, and you're going to hear why it's significant on what he removed actually from there. As you can see here, the section he's relying on specifically says for study prior to final approval. It doesn't say at the time a zoning compliance permit application is submitted. Those are important words, and you're going to hear why those are significant and why the positions set forth by the petitioners are misplaced based on their reliance on that provision and the others they also relied on in their case. We've heard a lot, too, about the landscape plan. But it's important to recall what Ms. Eisenhower testified to as to whether or not a landscape compliance plan was required at the time a zoning compliance permit application was submitted.
So you weren't routinely declaring applications to be incomplete, insufficient, not submitted if they didn't have a landscape plan like this?
Correct.
Can I ask a question? Could you go in front of the planning board for approval without these items, without the,
You could go in front of the planning board without them with the condition that they be submitted prior to the permit being issued.
okay.
So that's what Ms. Eisenhower said. There's no need to have a landscape compliance plan at the time a zoning compliance permit application is submitted. You could even go before the board without it. It would just be, the approval will be subject to condition that that is provided at a later date. She reiterated this same thing the next day. Mr. Henning, I believe, also asked you last night about the need for a landscape plan, and please correct me if I'm wrong, but I believe your testimony was that a landscape plan from a licensed landscape architect was not required for purposes of submitting a zoning compliance permit application, right?
Not for the purposes of submitting an application.
Again, her testimony is unequivocal. There was no need for a landscape compliance plan at the time the zoning compliance permit application is submitted. That gets us now to argument number 2. The response to Ms. Eisenhower's questions in her May 17, 2021 email. Petitioners are claiming that the response was inadequate, but it's important again to hear what Ms. Eisenhower had to say about it. And I believe it was your testimony yesterday, too, that the October 2021 revised site plan responded to each of your questions and comments that you sent to Mr. Day on May 17th, 2021, correct?
Correct.
So just for the avoidance of doubt, any questions that were in the May 17th, 2021 email from you to Mr. Day were adequately addressed, in your opinion, by the October 2021 site plan?
That's correct.
Again, unequivocal. The October 2021 site plan adequately addressed the question she provided to Mr. Day in May of 2021. Ms. Tuck echoed that sentiment. And then if you turn to page RD 160, we get to their actually conclusion or argument that they make. And then at the bottom, it's sentence towards the bottom that starts with, as a result, the developer's failure to respond to the town's questions resulted in a discontinuance of the application review, and the version of the development regulations in place as of January 22 applies to this application, not the version of the ordinance in place as of May 17, 2021. Did I read that correctly?
You did.
Do you agree with that statement?
I do not.
Why not?
Because I believe that the developer did respond to the town's questions within a reasonable time period.
And Ms. Eisenhower previously testified to those facts too, is that correct?
Yes.
So you have both Ms. Eisenhower and Ms. Tuck, the town planning directors and zoning administrators, testifying unequivocally that the October 2021 site plan responded to the questions. One of the positions that the petitioners then have tried to take is say, well, the October 2021 site plan should be treated as a whole new separate application, and therefore it's not responsive. But as you can see up there, that question was directly asked by Mr. Duroni to Ms. Eisenhower. And her response was no. So they weren't really, it wasn't seen as a separate thing at that point. Right. Ms. Tuck also addressed that during her testimony.
So it's just very peculiar, the terminology that a lot of people use when they submit stuff. I think, you've heard tonight a lot of reference to application, to submittals, to resubmittals, to amendments, to revisions, to people frequently confuse these terms and overlap these terms and misapply these terms. In May, we received an actual application form. that is an application for a zoning permit, and with that came a site plan. This submittal in October did not come with a new application form. They describe it as an application. The site plan is part of that application, and it appears to be a revision. Also, this is a site designer issue, but you'll notice you have these bars on the side. So all site professionals they have this title block, and it'll label all of the various versions of the plan and date them. And they put the initials of the person oftentimes, or how many pages were submitted, or the person who drafted it. These are revisions. That's what the purpose of these lines on the block is, to identify the revisions. So this is a revision to a May application.
So again, petitioners are arguing that HS Robin Hood failed to adequately respond to Ms. Eisenhower's May 2021 questions, but both Ms. Eisenhower and Ms. Tuck disagree with that position. Petitioners are also saying that the October site plan should be treated as a separate application, but both Ms. Eisenhower and Ms. Tuck state it is not a separate application, it is simply a revision to the May application. You're also going to hear directly from Mr. Day about what his intent was with submitting that. You're going to hear from HS Robin Hood on what their intent was for submitting that October application. Or, I apologize, revised site plan. The argument number 3, then, is Mr. Day placed the application on hold through this email. What's important there is Ms. Bernstein testified on this issue and what she thought that meant in her capacity as an expert. Here's what she said.
I remember seeing where the applicant asked to put their application on hold.
You're going to have to ask a witness that, not a board member, if somebody wants to.
Just go back into the book, yeah, I guess.
Could you ask a question again?
Is this that document?
Yeah, this was in, so asking not to be put on the next month's agenda is also saying we want our application to be put on hold.
I read this as, please do not put this on the agenda until we can get back to you. So it's definite with the wording of that request.
Okay.
Is that also the same kind of basis that they used this determination on? And forgive me, Mr. Hanson, if here's a question.
Would that be the same thing as saying, do no more work or consideration of this, just because you've kept it off the agenda?
I think this is just asking, don't put it on an agenda.
Okay, so, but if they're then doing more work or consideration of the application, would that be on hold?
I am not sure what work one would be doing on a project if you receive a request from the applicant to not put it on an agenda. To me, that's a signal, let's press pause. So I wouldn't see any active work that I would need to necessarily be doing until I get a signal from the applicant, okay, we're ready to go. But I'm not going to speak to what, would happen in Woodfin and what they would be doing. Is the processing is the term that was used last night.
Good. Thank you.
So she says she can't speak to what would happen in Woodfin in the processing based on that email. We do have Ms. Eisenhower, though, testifying what did happen in Woodfin.
Did you stop processing this application after you received this email from Mr. Day?
No, I did not.
And why not?
I didn't interpret his email to say, stop processing the application. I interpreted his email to say, we're not ready for review by the board.
So it's pretty clear she didn't take it as a hold. And you're going to also hear from Mr. Day what he meant by that. Finally, we get to argument number 4, where they are arguing that the October 18th site plan constitutes a group development, and there's essentially two components to that argument. One is that the site plan depicts more than one building, and the second is that the site plan discusses the potential for short-term rentals, which then converts it into a hotel or motel. Again, I come back to the September 30th, 2022 determination because that's what we're guided by. That does not have anything to do with the October 18th site plan. It is simply saying that a revised site plan that consolidates the residential units in many areas into a single building is a multifamily building, and a multifamily building is a permitted use. That's what the board is tasked with determining, whether Ms. Tuck was correct in reaching those determinations, not what's in the October 18th, 2022 site plan. That said, you've heard a lot of evidence, and now is the time we have to present our case, and we'd feel remiss if we did not actually address those arguments. So you're going to hear from the architect and the engineer that prepared those site plans. But I also, before we get there, want to address what we've heard so far.
Whether that's going to be all enclosed space or not, based on that design.
I mean, it looks like it's all enclosed space to me.
And you would have opportunities to further verify that in the further steps of the review process, is that right?
I could, but I don't know if it's necessary because the applicant stated that it's a single building and their designer stated that it's a single building and it's their professional obligation to provide correct and factual information on their plans.
So it's their professional obligation to provide correct and factual information on their plans. That plan discusses one single building. It doesn't discuss two, it doesn't discuss three. Ms. Bernstein was also asked in her professional capacity whether or not this was one or more buildings. As you will see, she was unable to actually provide any definitive response.
And can you, and I can, okay.
Can you definitively say that it's more than one building?
We would need more information, I think, to understand what's going on, but when I look at all of these plans and everything that's been provided, I felt like it was intended to be multiple buildings.
That was it sounds like that's your gut sense, but you can't state definitively it's one or the other.
So I guess let me add this. So in your professional opinion, you would say you would need more information. In your personal opinion, you're saying you don't think it's one building, if I'm correct, understanding you?
I think that is correct.
Does that answer your question?
If you receive...
So again, the burden is on them. They haven't met the burden yet, but there's going to be additional evidence that will show why it's a single building. They go then on the short-term rentals, and their position on the short-term rentals is related to, well, we should start with the fact that the Woodfin ordinance specifically defines short-term rentals. What they don't address is that short-term rentals is not listed in the exclusions to dwellings. That's critical. They try to equate it to a motel, hotel, but short-term rental is a defined specific term, and the fact that it does not appear in the exclusions to the term dwelling stops the argument. That's all the argument has to go to. They, though, move forward with the Planner's Dictionary. But as you heard from Mr. Green, the Planner's Dictionary cross-references terms that relate to each other. What you also heard from Mr. Green, though, is that the terms hotel, motel don't cross-reference short-term rental. There's just no relationship. And for that reason, we believe that they have not met their burden on argument number 4 as well. And we would ask that the board, after hearing all this evidence, affirm the determinations of Ms. Tuck. Thank you. All right, 6:50. Before we call our first witness, I didn't know what the board's preference was. I believe the direct may last 30 minutes to an hour, so I didn't know if you'd want to take that break now.
You said 7, I'm happy to break now.
Okay, let's take a 20-minute break. We will resume at 7:10 by that clock. So we'll take a short recess.
There's his in there.
Yeah, I saw it, thank you. So, Brian,
Yes, ma'am.
when can I ask my question about how many of these were submitted?
So either, I mean, if you're gonna ask a specific question of a witness that you wanna know that may not get back up here, at the end of the case, you could ask that somebody recall that witness so that you could ask that question.
Okay.
But they may, live mics, they may, thank you. I don't know who's gonna be called, so I don't.
Yeah, you can't really answer it.
But if you don't get your question, answered, you can request that somebody recall one of their witnesses so that you can ask them. Maybe dinner.
Yeah, really.
They made it that way eventually, and I just think every single day I think of that, but every, you know, to the cause. No. Oh.
actually said it. I loved it though, I actually loved it, so it was nice.
I did a major transaction in a train from Green Patrol.
Oh, where?
It's here in the Dallas office.
Yeah.
This goes back. Huge contract.
Okay. Yeah, I don't even look down there, I forget his name. Yeah, honestly, they do a lot of training around
Yeah.
It wasn't me. Oh, yeah? He did. Who? Oh, really?
Sure.
Oh, okay. Yeah. We don't really do this anymore. Well, I mean, I don't think anybody yet. No, it's not really about that, it's just, I have a 7-year-old and I was like, I'm not getting no hours, and raising a 7-year-old. So John?
Yes.
What happens now? You call witnesses?
Call, same thing they did. Yeah, call witnesses, get through them as best and quickly as we can.
So you said,
We're not anymore, actually, it's probably, we're best friends.
just because we made this long doesn't mean it's easy.
Yeah, I don't know, I'm sure it's never easy. Really? That's so funny.
So it's not selling. And she was queen for it. You know, we have a balance. We still have trouble balancing expectations.
Yeah, of course, yeah.
Birthday is.
Oh, right.
That way we're at the same way.
Yeah, yeah.
My wife is very big. Say he was all silly.
Happy birthday.
Yeah.
Yeah, we text.
Yeah.
Yeah. It's 50th or something like that.
Yeah. But otherwise, yeah.
They do.
Yeah,
Right
that's
there.
all right. Yeah, understood.
I know, I love the fact that they took these photos. I just wish they had a date. I wish they had just a little date on the side. Oh, yeah. Yeah, now I'm cold.
Yeah.
Don't you wish they had a date on it? Just so we could just kind of figure it out how far back?
Date and all the names.
Well, the name, well, the names have been kind of see. Jerry Beelon, you know him, right?
Yes.
Yeah. He's been mayor for a couple of years. So this could have been a long time ago.
How you doing?
Good, real good. Real good. Oh. What kind of chips are they?
Pringles chips, that'll make it more different colors, all things are, or tacos.
Tacos, right, that's what
I'm
I thought.
surprised there's not chocolate here, like it's the day after Valentine's.
I was looking for.
Come on, people.
There wasn't any.
Sorry, Chris.
It's actually warmer than when we came in. 2 degrees
Is it?
warmer. You're watching the thermostat to a degree, huh?
I said I was gonna put my coat on. I was looking for something sweet, yeah, and then it said there should be chocolate since it was just Valentine's Day.
That's sweet.
Thank you, though. Oh, thank you.
There's some mints on off.
Oh. Mints don't cut it.
Anyway, no, I know, it's like,
No.
it's not sweet.
I don't even eat mints anymore.
John, do you need this desk?
No, I think I'm okay. Thank you.
Okay.
You're cold. Okay, we have 1, 2, 3, 4. So you're back, okay? Good to go? Board good to go? Okay, I'm gonna call the meeting back to order, and we can resume. Mr. Portnoy, you are up.
At this time, we'd like to call Mr. Tom Terrell to the stand.
Mr. Golden, can you please swear in the witness, please?
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? If so, please say, "I do."
I do.
Thank you.
All right, Mr. Terrell, can you please state your name and introduce yourself to the board?
My name's Tom Terrell. I'm a partner in the law firm Fox Rothschild. We're a national firm, but I'm in the Greensboro office.
I want to first pre-mark this, I believe it is Exhibit 11.
Thank you.
Mr. Terrell, do you recognize the document I just handed you?
I do. This is probably a year and a half, 2 years old, but it's my law firm's webpage biography.
Biography, and it addresses some of your background and experience, is that correct?
It does.
Okay, I want to dig in a little bit on your educational background, professional experience, and all that, but at this time, I'd at least like to move to admit Exhibit 11 into the record.
Okay, do we have any questions from the board? We haven't seen it yet, but, okay, we will admit this as property owners Exhibit 11.
Yep.
Thank you.
Yeah, you bet.
All right, and Mr. Terrell, while they have that before them, I kind of want to walk through your experience and qualifications. Can you tell the board about your educational background?
Yes, I graduated from UNC Chapel Hill with my friend Van Vogel, who was sitting back here with CRLU. Graduated from the law school in 1985.
And can you describe a little bit about your professional experience after graduating law school?
Sure. I graduated to become a litigator, but very quickly started to get involved in land use and zoning. It was in a High Point law firm, and within 6 or 7 years, that practice had spread to about a 10-county region. And it caught notice, and in 2000, I moved to what was then the statewide firms, Smith Helms, Mullis and Moore, and then an offshoot of that I stayed with, and then we merged with Fox Rothschild in 2018. Throughout that time, I've been doing land use and zoning for about 37 years. 25 years at least, I've been doing that almost exclusively as my practice. I represent counties, cities, private developers, opponents of projects. I speak and teach, but I do notice that this is old. It says I've
handled matters in over 350 local governments in 4 states. It's now over 400. I don't keep an index on that, but I had a team meeting last Friday, and presently I'm in 33 jurisdictions, Woodfin being one of them.
And it sounds like from what you said, your experience is basically on all sides of what we call the V, between the government, the developers, opponents to developers. It's spanned all of those, correct?
That is correct.
Okay. Can you expand just a little bit more on any awards or recognitions you've received during your career?
There aren't many awards and recognitions for people in land use and zoning. There's actually only one that I'm aware of. It's called the Award of Excellence. It's given by the Bar Association, the Land Use and Zoning section, and I was I believe, the 3rd recipient of that.
And are you a member of any professional organizations?
Quite a few. Some of them are industry specific. I do a lot of work, for example, in renewable energy. That's a large group of clients. And I am probably in 2 or 3 different professional organizations that way. But the primary one really is the zoning and land use section with the North Carolina Bar Association. I do attend all the environmental law section meetings.
And you just mentioned the land use and planning section of the state bar. Have you held any positions in that organization?
I was a founding member of that, and I was also the chair in 2012, 2013.
And have you published any articles or other types of publications on land use and planning and zoning regulations?
Oh, quite a few. I've done a chapter in a book on the Telecommunications Act of 1996. I have probably, I don't keep a list of these things, but I've probably done 20 articles at least in something called the Land Use Law Quarterly. For about 6 or 7 years, I did a blog called North Carolina Legal Landscapes. I don't have time to do it right now, but I commented on the zoning process, many aspects of the zoning process, about cases that just had to come out, things like that.
Have you done any presentations and CLEs in addition to those publications?
Oh, yes. I have. Again, I don't keep lists. A lot of people do. I've probably spoken to Bar Association continuing legal education seminars on in land use and zoning, maybe 15. I have done 2 or 3 for the environmental section, 2 or 3 for the government section. I have spoken 4 or 5 times at something called the NCAPA annual meeting. That would be what Ms. Tuck is a member of, the North Carolina Association. It's American Planning Association, North Carolina chapter. I have spoken a couple of times for the counterpart of planners called CZO. And then I have spoken to the municipal and county attorney continuing legal education seminars 4, 5, 6 times.
And there's been a lot of evidence and testimony in this case on Section 160D of North Carolina General Statute. Are you familiar with that version or section of the code, North Carolina Code?
Is that a trick question?
You tell me.
Yes. If I may give a little bit of a background, when I was the section chair of the Land Use and Zoning section in 2012, 2013, the Board of Adjustment statute, the statute that governs what this board does, had not been touched since 1923. And we decided that we would form a drafting committee to modernize that. It was a democratized process. We sent changes out to every planner, every attorney who did land use and zoning. We sent it to everybody. We got input, and it was approved by the General Assembly unanimously in both chambers. During that process of a very small drafting committee, I proposed that we do that for the entire North Carolina general statutes of land use and zoning. And about a week after the Board of Adjustment update passed, Professor David Owens at the School of Government called me up and asked me if I was serious, and I said, yes, I was. So we met, Professor Owens and I, for the next 6 months or so at the School of Government once a week, and he was the one who was the person moving around all the statutes, and I was the one with the input, the criticism, the observations that he would react to. And then we expanded to 2 more people. One of them was an attorney here, the city attorney for Asheville, Robin Tatum, joined that committee, and another woman. And after 6 years and a lot of false steps, it became law on July 11, 2019.
So the short answer is yes, you are very familiar.
Yes.
Would be
Yes. Well, the true answer is I was a part of so many different versions of it that even today, sometimes it's hard to remember if it's language that was omitted or included, although I've read it enough times now that I think I remember what passed.
And have you spoken before the General Assembly or local governments on these issues?
Yes, in both for the Board of Adjustment and for 160D, I testified each time in front of 2 or 3 committees, House and Senate.
At this time, we would ask that Mr. Terrell be qualified as an expert in the areas of zoning, land use, planning, and regulation.
Mr. Chair, I just have a couple questions on the water
Sure.
section of this before we make
We can let Mr. Norris speak now.
Oh, absolutely, or ask his questions, yeah.
Yes,
And Mr. Noor, maybe, does he need to go up to the
You
mic?
can come up if you'd like.
please.
Just a couple clarifying questions, Mr. Terrell. We got to meet for the first time this evening.
We did.
I wanted to ask you a few things. Do you have any planning degrees?
I do not.
Okay. Have you ever served as a zoning administrator?
I have not.
Have you ever worked in the planning department of a municipal government or county government?
I have not, but I have advised them on numerous occasions for the client, when the government was my client, I have advised them as to planning law and have been to many of their conferences and read a lot of their publications.
Okay, but if I'm hearing you correctly, you didn't work for any of those governments in those departments?
I was never employed, but I have advised them.
Okay. I think I did not hear, have you ever been qualified as an expert? And I don't exactly recall, what was the area that you were asking that to be qualified in?
We are in zoning, land use, and planning, and regulation.
Have you ever been qualified as an expert in any of those areas before any tribunal?
This is only the second time I've been asked to do that. Typically, I stand where you're standing.
Okay. And what was the first time?
The first time was a condemnation case in Winston-Salem.
Okay, that was a condemnation case, so in that context, were you qualified as an expert in those areas or in condemnation?
I was qualified in multiple areas in that case. I was qualified in the zoning process. I was qualified as somebody, as an expert in land use and zoning. I was qualified as somebody who understood the local process in Winston-Salem, Forsyth County, where that case was. And that may have been it. There may be more. I don't recall.
Okay. But this will be your second time, correct?
Yes, that is correct.
And that's a good segue into, I think you mentioned multiple jurisdictions. Do you regularly practice in the counties within western North Carolina?
I have, yes, I have in this area, Woodfin twice, actually, Asheville several times. I have a matter in Asheville as I speak. I've handled something in Fletcher, Black Mountain, Buncombe County, and then I have something in Hendersonville currently, but I've done something in just about every western county, maybe not Cherokee.
Okay. If I heard your testimony correctly, though, that's in sort of my role as the attorney, not in
That's
the
correct.
planning or zoning role.
That is correct.
Okay. The periodical, or I think you mentioned the Telecommunications Act, you'd authored a chapter or something?
That's correct.
Okay. That's not land use and zoning related, correct?
It actually is. The Telecommunications Act of 1996 was the federal government's effort to codify the rules by which local governments could approve or disapprove a cell tower or a broadcast tower.
Okay. Just a couple more questions. Have you ever, again, you said you hadn't worked for any of for a planning department or a municipal government in the context of one of those departments internally. Have you had to serve in the role as either zoning administrator or other designated individual interpreting a town's code for the town?
I've actually written town codes, zoning codes and comprehensive plans, and I have litigated zoning ordinances and comprehensive plans on numerous occasions.
My question, though, was, did you ever serve in a role where you were tasked with interpreting the code for a municipal government? In the role like a zoning administrator like Ms. Tuck?
When I have represented counties or municipalities, it's typically, not always, but typically in a zoning context, and interpreting the applicable code for the issue at hand is always part of that.
But you weren't making any of those zoning determinations, correct?
I probably was in litigation, but if your question is, have I sat in the role of Ms. Tuck?
Yes, that's my
I
question.
have not.
Just to follow up, when were you retained to give an opinion in this case?
Last Friday.
And have you reviewed the transcripts in this case?
I have, depends on what you mean.
I'm sorry, I didn't catch that, sorry.
It depends on what you mean by reviewed. I have flipped through the transcripts. I do have the transcripts here with me.
Okay. Have you read them all?
No, word for word, no, I have not.
Okay. Have you, I assume, I think you said to me before we got up here that that's the record of decision. You have other materials in front of you. You reviewed the record of decision?
I have.
Okay. This point, those are my questions. If I can have just one second to talk with my client. Those are my questions for Mr. Terrell and Wadier.
Can I ask a question of the witness? I was reviewing just briefly, I didn't have a chance to read your whole history with your experience, but one just piqued my interest that it says that you're North Carolina's go-to attorney for mining companies. What is that?
It means, the genesis of that is that early on, going back to the 80s, lawyers who did land use and zoning did it in their backyard. I took the skills of being able to read a zoning ordinance, knowing how to understand subdivisions and subdivision law, how do you read engineering plans, traffic impact studies, and I took those skills to a broader region. And very soon, I started being sought after by companies that I have always called the hard-to-permit industries, because they're looking for somebody who has a different level of skill than somebody who just knows how to shake the hands of the local decision makers. So mining companies, you do one, and then the next company hears what you've done, and then they hire you. I also do a lot of work with solid waste, something we all need, but it's very, very, very hard to permit. And believe it or not, renewable energy, which is my favorite industry, is extremely hard to get permitted anymore.
Okay, thank you.
Yeah. I didn't seek out the mining industry, if that's,
Mr. Corner, do you have more questions before we?
I have no more
Adjourn?
questions for Mr. Terrell to the extent we are on the issue of whether he's qualified as an expert.
Is there anyone else on the board that has questions for the witness, Mr. Terrell? The board?
The town has no questions or objections here as qualifications.
Thank you, I apologize, I almost overlooked you. That being said, then, do I have a motion to approve Mr. Terrell as an expert witness in the land use permitting zoning field? Did I kind of cover?
Yeah,
that?
zoning, land use, planning and regulation.
Okay, do I have a motion to have a second?
Second.
Second. All in favor? Aye. Anybody against? Okay, so he is now going to be considered an expert witness in those fields.
Thank you.
For this case.
Thank you. And Mr. Terrell, my initial question was what you did today in preparation. I believe Mr. Noor kind of addressed that already. But if you want to
well,
expand a
it's
little bit.
actually, it's a little bit more extensive than that. I did not have time to read the transcripts and watch the videos, but I have read the entirety or flipped through as, to relevant sections of the entire town code. The former zoning ordinance, the current zoning ordinance, Mr. Noor's brief, his expert, Mr. Green's report. I have read the brief that your team prepared. Of course, the record of decision, those are the main things. And then there were several cases that I had independent knowledge of that I have gone back to review, and of course, Chapter 160D.
Well, today we are here because the petitioners are challenging determinations that are related to a zoning compliance permit application that was submitted by HS Robin Hood owner on May 17th, 2021. Before we get into the specific positions that the petitioner set, I just want to ask if you could explain what a zoning compliance permit application is.
Sure. In fact, I think this is missing from the materials. Every jurisdiction that is considering any type of land use change has to have some type of preliminary investigation or look at something to see if it's going to be rezoned, to see if it meets the general standards. Sometimes you do it in fact, most of the times in most jurisdictions, it's just a pre-application meeting to make sure that the tract of land is big enough. Is it a use that's allowed in the zoning district? Is it consistent with the comprehensive plan? Are there traffic issues, environmental issues, things like that that have to be flagged and identified? And then you go through, the next step is the entitlement. Now, in Woodfin, there is a zoning compliance permit that is sort of nestled in there in that early stage because the materials that are identified in 54-35 are broad materials. Now, it's important to note that this is what you take through for board approval. It's a process called entitlement. You don't spend at the entitlement stage the money that you need to spend for all your engineering, for all of your sedimentation, erosion control, all your architectural renderings, because depending on the project, sometimes those costs can go into the hundreds of thousands of dollars. They can even go into seven figures. So you wait until you have done the preliminary, or have had the preliminary decisions made at the entitlement phase. The zoning compliance permit in this ordinance is part of the entitlement process where everything is broad. There are claims in here that HS Robin Hood should have brought all of its construction drawings and its final plans and all of that. No, that is a misapplication of the process. And if you ask me the questions, it's a misapplication of the ordinance.
So just looking at the ordinance generally, you said, there's a preliminary aspect, which is entitlements, which the zoning compliance permit application is. What's the rest of the process? Can you explain to the board based on your review of the ordinance?
If you don't get through the entitlement phase, then you can walk away, you can litigate. There are a number of things you could do. You can come back again and reapply again, maybe for something different. But if you get through entitlement, that's the beginning of the hard work. Now, the entitlement phase is what people see. That's the controversial rezoning. Sometimes they're played out, in neighborhood communications and people coming to the board meetings. It makes it to the newspaper. But if someone who's developing land gets past that, the next thing that they do is that they put their engineers and their environmental teams to work next, because you have to be able to identify, are there wetlands, are there streams? You cannot get out of protecting those resources. You have your architects and other types of civil doing what they do, and depending upon the industry, there could be different consultants, but you eventually come to a point where you have all of your construction drawings. You have everything that you need to come in, and I'll point to Ms. Tuck, who I just met today for the very first time. You come into someone like her, who is a gatekeeper, and say, here now are all of our construction drawings. So we're entitled. Now that's when the town looks at in detail, well, do you meet the state building code so you can get a building permit? Do you meet the Sedimentation and Erosion Control Act provisions so we can give you a permit to start clearing land? Things like that. And, do your plans show that you are far enough away from streams and wetlands? And those are in very detailed. Of course, if you've ever seen construction drawings, they typically, they're now submitted electronically, but they're, back in the day, they're just huge sheets of paper with sheet after sheet after sheet after sheet. And the sheets are marked, they have the dates of when they've been revised, and it's all part of a process, because typically, and I don't know if Ms. Tuck or Ms. Eisenhower testified about this, there's a constant barrage of questions and meetings among the development team and the jurisdiction through that process.
So you were just talking about kind of a back and forth between the government and the developer during the construction phase process. Is there a similar back and forth in the in what you call the entitlement process, or in this case, the zoning compliance permit application process?
Yes, and I didn't mean to interrupt. Some cases are very simple. You do a pre-application meeting, and then you submit the materials, and it gets rezoned. Anymore, it's harder to do any type of land use change. Half of your time is spent managing the emotions of people who are opposed to change in an area, and that's a big part of it. But there is a constant back and forth with staff. The staff are constantly, if they're good at what they do, they're asking questions, they're identifying issues, and a good developer will be responsive, and sometimes there's a tug of war. The staff may want you to give extra right-of-way or extra setbacks for whatever reason, and you go in and say, yes, but do you understand how many 1,000 square feet of leasable space is lost when the dominoes start to fall? And you have these meetings and discussions. Sometimes it's a phone call, sometimes it's by email, sometimes it's Zoom or, eyeball to eyeball.
So this entitlement process can last a lengthy period of time?
It can.
And there can be multiple revisions of site plans and things of that nature during that process?
Depending upon the project, it's rare for there not to be site plan revisions of some sort.
I'd like to jump in a little bit, and you mentioned earlier that the petitioner's application is inaccurate. I kind of want to start walking through that, and really by going through Mr. Green's report, and again, just making sure. Did you review Mr. Green's report?
I did.
Okay. And
May I open up to, I have it in front of me.
And I want to kind of walk through each of his opinions. His first opinion is that the May 2021 application and site plan was not legally submitted for purposes of triggering the permit choice because it didn't include four things. He says it didn't include the dimensions of the proposed buildings, it didn't include architectural design guidelines, it didn't include a landscape compliance plan prepared by a licensed landscape architect, and it did not have approvals for sanitary, sewer, and water distribution systems. So those were the positions that Mr. Green set forth in his report. I'd like to start just and take each of those one at a time.
Okay.
On page 3 of his report.
May I say, first of all, you didn't ask the question. There is no such thing as a term. It's being bandied about here, legally submitted.
I apologize, but I'm going to need to object. This is the opportunity for the witness to answer questions that are asked by the attorney or the board, not necessarily to just in a narrative form speak about whatever you would like to speak about. So I think that those questions are asked, they're answered, and we proceed in that typical format. So I object to the comment that's about to be offered.
Okay. Sustained, and can you let the attorney ask you the question?
Sure.
Is there something that I either misstated or something that was inconsistent with what I said, or based on the positions that I read with regard to Mr. Green's opinions?
In my experience, legally submitted is a concocted term. There is nothing in a statute, there is no phrase that I've ever seen in a case that uses the phrase legally submitted. There is, the 54-35 says these are the items that an applicant shall bring to the zoning compliance meeting, but the statute says submit. And there are many ways to submit. You can submit electronically. You can, depending upon what the ordinance says, you could do it verbally for some of the materials that you will be describing. So it's not, there is no magic way that something is submitted.
Jumping back to Mr. Green's report, on page 3, he states, "There is no indication in the packet presented to the town on May 17th, 2021, that it provided the dimensions of the proposed buildings." In my understanding, again, is you reviewed the record of decision, correct?
I have.
And based on your review of the record of decision and other materials, do you agree with Mr. Green's position?
Let me first find, it's on 12.3.
Correct.
Did you just read?
Yeah.
Shall be accompanied by the locations and dimensions of the proposed buildings.
Correct. He says there's no indication in the packet presented to the town on May 17th, 2021 that provided the dimensions of the proposed buildings.
Let me, I disagree with the position that you've taken and that Mr. Knorr has taken. Really clearly I do. When you have an engineer or an architect, as if this was the case, submits a plan and says, these are to scale and these are the locations of the buildings, that's all you need to know, that they are to scale. So the professional says that. Now, in this case, it says dimensions of the buildings. There is no magic way for a dimension to be shown. Now, in the vast majority of site.
I'm sorry, I need to object. I think the witness was qualified in the areas of land use and zoning, not engineering and drafting of site plans. And so I would object to his opinion being offered on the way to show dimensions or getting into areas outside of the expertise he was qualified for.
This goes directly to the opinions he stated in interpreting Woodfin's ordinance and what's required and what's not required for purposes of submitting an application.
And if I may, I'm raising my hand. Again, his testimony he was about to say was there's no magic way to indicate dimensions or to that effect. I can't recall the exact words. That's talking about the engineering work, the site plans, not interpreting the code, nothing like that. I think this is outside of the scope of experience. Would ask that objection be sustained, not really going from this context.
I would be glad to testify to the thousands of site plans I have seen. I know you don't want the answer, but I have seen thousands of them, and I can tell you
All
what
right,
they
can we,
have.
I know, I'm trying to think. If the witness can hold on for a minute, and let me finish what we're doing here first, and wait till you're asked the question. So your objection is that he is not testifying as an expert witness that we qualified him as. Now, I'll ask the board, because I guess my personal opinion is I have to want to sustain this objection because he was put in as a land use, not as an engineer. So do we agree he was not? Now, if Mr. Portland can ask the question differently, that'll be, we can answer, but I don't think we should allow him to just give open testimony on things he's not qualified as. Okay, so the objection will be sustained, and if you could please re-ask the question, and if the witness can stick to answering the questions that he's been asked. Please.
Mr. Terrell, based on your review of the Woodfin's ordinance, is there anything that indicates how a site plan is supposed to indicate the dimensions of a building?
Yes. The job of a land use and zoning attorney is to be interpreting and presenting site plans. You cannot be, I'm speaking. I
And
can,
you're allowed to make objections for the record before you provide your answers, so that the record is protected. And the board is entitled to rule on those objections. My objection is that he's not answering the question that was asked. He asked, where in the ordinance is this information? He's now talking about what a zoning administrator should do. It's not responsive to the question that was asked. I ask that you be again directed, as the chair already did, to answer the questions that were asked.
Okay, sustained, and you're asking the question, okay, but if you could please answer the question that's
I'll
asked
ask
to
the
you.
question.
Again, I think the question was, is there anything in Woodfin's ordinance that specifies how the dimensions are supposed to be indicated on a site plan?
No, there is not. There is nothing in the ordinance that says how dimensions are to be on a site plan. There is nothing in the statutes of this state, and there is nothing in a case that I have ever read in North Carolina that specifies how a dimensions of a building should be displayed.
Okay, and in this case, are you familiar with the graphic scales that have been included on each of the site plans?
I am. They are typical graphic scales.
And based on your reading of Woodfin's ordinance, are the graphic scales sufficient to show dimensions of a building under this ordinance?
That not only are they sufficient, but that is how it is done in the industry.
Again, I will object and ask that the last part of the answer be stricken, because the board has already ruled that he doesn't have the expertise to give an opinion on what is done in the industry.
He's testified that he's done 400 different counties. He's done this for 35 years. He's worked with counties, developers. On opposition to that, I think he can speak to his experience in this case.
I'm not offering an opinion.
Hang
I'm
on a
offering
second,
fact.
hang on a second.
I think there's a difference between his experience and the industry as a whole.
So we do want to continue. Okay, so we're going to overrule this, but I'm going to ask that it's worded.
Mr.
towards
Chairman,
his
hold on.
expert-
I think Mr. Hanson was,
No,
I'm sorry.
I was saying I would sustain the objection because he's talking about for the entire industry, and he's only been qualified for
Oh,
his
okay, I
experience.
misunderstood your.
And I can just,
So is everybody on the board agreed? Okay, so we're going to sustain that, my mistake. We would like it worded differently, so we stick to his expertise, not.
the objection was just for the last part of what Mr. Terrell
So we're
said,
going
and
to
that
strike the
was
last section.
just the last section.
Okay, so we'll strike the last section from the record, and Please ask.
Mr. Terrell, based on your experience, is it common for site plans to contain graphic scales like the ones here in order to show dimensions of a building?
I have seen thousands that do that.
So just to be clear, again, do you agree with the positions asserted by the petitioners and in Mr. Green's report that the May 2021 site plan did not indicate the dimensions of the proposed buildings?
That is correct. The only time you see dimensions are in construction drawings for a building, and that's not what this is.
So in your professional opinion, was the May 2021 application incomplete because the site plan did not contain dimensions of the proposed buildings?
It was not. In fact, the dimensions were there to the extent the graphic scale was there.
Another item that Mr. Green testified about was that his position was HS Robin Hood's application was incomplete because it did not include approvals for proposed sanitary sewer and water distribution systems from the appropriate state and local agencies. And on page 3 of his report, towards the middle, he cites to 3 different provisions, section 5411, section 5437, and section 54318. So I want to kind of address each of those provisions in turn as well.
Okay?
So starting with the first one he cites, section 5411, and it says, no zoning permit shall be issued until a safe and adequate water supply and sewage disposal system is ensured and a sanitary permit is issued by the appropriate county and state agencies. Did I read that correctly? It's on the-
You read that correctly. You will note that the date on that originally is 1973. This is a reference to well and septic.
And that was my question is, based on your professional experience and your review of Woodfin's code, does this provision require HS Robin Hood to ensure safe and adequate water supply and sewage disposal system at the time it submits its zoning compliance permit application?
Well, no, it does not, but it's also outside of the article. This is guided by 54-35, which says you provide what's in this article. And that's a very specific term. Now, in the new code, it says you provide what's in this chapter. And under the canons of construction that guide all of our industry attorneys, when a legislative body uses a term like chapter, the presumption is they meant to say chapter. When they say article, the presumption is that they meant to say article. There are North Carolina Supreme Court cases that say when your powers are expressed in Article 18 or 19, you cannot extrapolate that power to Article 20 unless it's also in Article 20. So it's not listed in the article, so it's inapplicable for that reason as well.
Okay, you said for that reason as well. Was there another reason that it's inapplicable?
Yeah, because this is not a well and septic project. And this is clearly when you are referencing a sanitary permit by the county, that's for a septic tank.
So there's 2 reasons, in your opinion, after reading the ordinance as to why 5411 is inapplicable to this case, correct?
That's correct.
So is it your professional opinion that section 5411 is inapplicable for purposes of determining whether HS Robin Hood has submitted an application for purposes of triggering permit choice provisions under North Carolina law?
That is correct. In fact, in this case, to be clear, you don't have to come in. When there are utilities near a project, water and sewer, all Ms. Tuck has to do is look at the utility lines. They have the maps here. They know where they are. It would be your company's responsibility to pay for it to be hooked up to it, but whoever owns those utilities has no legal authority to tell you you cannot use them unless you're outside the jurisdiction or something like that, or if there's an water allocation issue or a wastewater treatment plant allocation problem, they cannot deny you. So this is not something that even could be applied to this type of project.
So that's 5411. That's one of the ordinance, sections of the ordinance Mr. Green relied on and petitioners are relying on. The next one they cite to is 5437. And that section is entitled Health Department Approval, correct? It's up on the screen as well if
Yes.
you need to.
Yes,
Yeah.
and I have it here as well.
Okay, and it says, where applicable, the zoning administrator shall not issue an application for a zoning compliance permit for any use, building, or purpose proposed for location of the incorporated municipality without written preliminary approval of any proposed water supply and sewage disposal facilities as required from the county sanitarian, Woodfin Water and Sanitary District, and appropriate state agency. Did I read that correctly?
You read it correctly.
And based on your professional experience and your review of Woodfin's code, does this provision apply to a proposed multifamily residential development?
No, and for two reasons. And then this one is in Article 2. So you can ask the question as to whether it should be presented as part of the other information in this article. But number one, it says where applicable. And that's something you have to ask, okay, what does this refer to and does it apply? Clearly, it doesn't apply because if you keep reading, this is an old ordinance that refers to homes and businesses on well and septic. It was approved in September of 1973. And when you say the county sanitarian, the county sanitarians were the men and women who went out to make sure the land perk for a septic tank. They went out to make sure they tested the well to make sure it's deep enough, the casings were adequate, things like that.
So is it your professional opinion that section 5437 is inapplicable to this matter?
It is.
Can I ask a question about that? So I'm just trying to think back to some of the earlier questions that came up with regard to the water supply. And you're saying that this is, relevant to wells or septic fields, but what about just regular water provided by the local water department, if it wasn't well?
That's irrelevant because this is saying you have to take in to the zoning administrator proof that you have permission. I mean, I'm paraphrasing, but that's back for when you had to show that your land perked and you had an adequate supply of water. In this case, you have public water and sewer up here, and the public, whoever owns the water and sewer, cannot deny them the right to access it. So permission is not the question that's relevant, so where applicable.
Right, okay. I guess I was thinking back to the adequate water supply, some comments that Ms. Tuck made, that we didn't have determination about what that water supply looked like yet. So this wouldn't be well water, but it would still be city water, and so it would apply to the city water.
Yes.
Okay.
So I have a question also. So I guess I'm a little confused because the question was asked if this is applicable and not. And it says where it's applicable, and you say it's not applicable. But I guess my question is, it clearly states Woodfin Water, which is a public water utility, the sanitary district, which would be the Buncombe Sewage Authority, MSD. So I guess I'm confused as to why you're saying it does not, if it clearly says those two things. Woodfin Water is a public water
Well,
supplier.
let's look at what it really says. It says, the zoning administrator shall not issue an application. And administrators don't issue applications, they issue permits. An applicant requested an application, so already we have something that makes no sense. But let's assume somebody was trying to say, the zoning administrator shall not issue a zoning compliance permit. Not the term, but let's assume that. To keep reading, without written preliminary approval of any proposed water supply and sewage disposal facility. At this point, once you are in a municipality, you don't need written approval to say, yes, you can hook on. As a citizen and a taxpayer, you have the right to tap on. Now, there may be regulations that are governed. You may have to pay a tap fee. You may have to pay all kinds of fees. Depending upon the county, you may have to pay an allocation fee, but that's not part of, it's nothing that they can grant you permission for. Yeah, the lines are there or they're not.
Yeah, the lines are there, but however, there's a difference between one home being hooked up to it and 110 properties being hooked up.
What is that difference?
I don't know, because I don't know enough about the water.
Yeah, and sorry, Mr. Terrell, you don't have to answer any questions that are asked of you if you just direct your questions to so if he asks you a question back, I would just ask you not to respond.
Oh, I
Is it-
And understood, and I think he was just trying to clarify, because she made a statement there was.
Oh,
difference.
okay.
I'm
So
trying,
he was
I was
to
asked
get
a
clarity.
question, but there was a statement built in, and I was trying to understand
Right.
what this alleged difference is, because if you have a right to tap into the public water and sewer, you have a right to tap in. It makes no difference whether or not,
Sorry, I'm gonna have to object again. In this witness's expertise is now testifying about tap fees and access to water systems. And that is not interpretation of the zoning ordinance. That is not the issues on appeal. And it is both irrelevant and outside the scope of the zoning.
First of all, he's zoning, land use planning, and regulation. Second of all, it's directly on appeal because you have contested and said that this applies. He is here to testify why that is inapplicable, and that's what he's doing.
Well,
yeah.
I don't think
Hang on a
there's
second.
any appeal about tap fees. So again, I think we're talking about things that are outside
Well-
of the scope here. Again, I'd ask the
Hang on a
board to
second.
rule on the objection before.
Yes. So I'm going to say we're going to sustain on your objection, and from the board and the attorneys, let's keep to his testimony, to his expertise.
would it help, Mr. Chair, if I said what's involved with being zoning and land use attorney?
No, I mean, you have to answer, it's up
Okay.
to them to ask you the questions.
Mr. Terrell, just to help provide some more background, can you explain what is involved in your experience as being a land use zoning and planning attorney?
Thank you. When you do,
He's already qualified as an expert. I think our time is best spent talking about the appeal and components, not about his expertise and what is included in that. He was admitted as an expert, we'll pass that.
He's talking about what's on appeal, though. This is, again, a section 5437 that they're coming is applies directly to our case. We are trying to explain why it's not. We have that right to do that. Mr. Terrell is up here to explain why that is inapplicable.
If this board thinks that testimony from him, based on his training and experience, would be helpful for a resolution of a disputed fact, you can allow his testimony.
Would like to hear it? Yes. Okay, so in that case, if I get this right, then your motion is going to be overruled. We're going to allow the witness to answer Mr. Portnoy's question.
And so I believe he was kind of actually addressing Ms. Hoffman's question, which was, what's the difference between 101 versus 110, and is there a difference?
Right.
And you were explaining that.
legally, there is not. And if I may ask the chair, if we're going to be going through this all night, it might be helpful if I said what's involved in practicing zoning and land use law.
Well, can you answer the board's question first?
Yeah, it's legally, there's no distinction between whether it's one or two. What you're raising is a policy issue, perhaps, but that has nothing to do with the legal issues before this board.
Okay.
Whether one draws more water or puts more sewer in, because that's not the issue that Ms. Tuck has to answer. It's not a question this board has to answer.
And then the witness will answer Mr. Portnoy's question, which
was, if you could explain what goes into being a land use and zoning attorney.
Yes, give me 4 or 5 minutes, but it's very, I have worked in many, many industries, many jurisdictions, but to do what I do, it's not, I don't go around interpreting the law. What I do is I meet with clients, I meet on site, I look at site plans, I look at site plans being revised. I put on my boots and I walk to see the actual streams and the wetlands that are on a site. I meet with the environmental consultants. I work with them on the site plans. I meet with staff. I have met with probably more transportation engineers than anybody in this room combined. I have read 250 to 300 traffic impact studies. I have my own personal copy of trip generation statistics and the highway capacity manual, which are the Bibles for data used in transportation issues. I have to deal in almost every project, except for solar farms and cell towers. I have to deal with the water and sewer issues that are available, what the laws and rules are related to utilities. I have to actually understand the construction issues. They can become involved with that in litigation. Trying to think, but I deal with the consultants as much or more than I do with the cases and the courts and the judges and the books. Now, if it goes into litigation, then I have to deal with a lot of things. But I have read through several hundreds of comprehensive plans, multiple hundreds of zoning ordinances. Sometimes I go through from start to finish like I did with this one. Sometimes I'm only going for a small section of that ordinance. But you can't be a good zoning and land use attorney without having thorough involvements. And as I said at the beginning, mine extends to 35 years in over 400 jurisdictions.
Thank you. And to get us back on what we were addressing section 5437 and whether or not you believe this provision applies to this case. And again, it's your professional opinion that it does not, correct?
That is correct. But this is why we have planners. This is why we have Ms. Tuck, because it says where applicable, and we hire professionals to look at something like this to make that determination.
And because it's your professional opinion that section 5437 plays no role for purposes of determining whether HS Robin Hood submitted its application, is it your professional opinion that that does not impact its rights under permit choice rules? Said that poorly. Is it your professional opinion that section 5437 plays no role for purposes of determining whether HS Robin Hood submitted its zoning compliance permit application on May 17, 2021?
Yes.
Could I ask a follow-up question?
I'm glad to.
So whose responsibility would it be to determine that the proposed water supply facilities were adequate and safe?
It could be, it depends on the jurisdiction, and it depends on where the water and sewer come from.
To this being speculatory about depending on the jurisdiction, we're talking about Woodfin.
Yeah.
And I think the question was about.
Okay, but it's not made at this stage. You don't make it at this stage, you make it at the construction.
You have an
My
objection?
objection was the speculation.
Okay.
And testimony to irrelevant out of jurisdiction situations versus this being about the town of Woodfin. It's particular.
All right, so sustained, can you answer within context of this case and this township?
Yes. It's made at two levels. First of all, a sophisticated company does not come to and identify a project like this that does not have public water and sewer. So they know themselves, and they have made that determination, but these are the issues that Ms. Tuck or whoever on her staff would look at the time of issuing construction permits, because that's when you get into the details of where that's when somebody will come in, and I had talked about the construction drawing sheets, those sheets that, will have where the pipes are, what is it an 8-inch pipe, is it a 12-inch pipe, do you need them to enlarge that pipe to serve a future area downstream, things like that. But that's when you're coming in for the building permits and construction permits.
Okay. So, you talked about an entitlement meeting,
Yes.
which means you look things over before you even start the process to make sure that everything is in place. So what you're saying is just the fact that there is a water and sewer system, that goes by the property, then that's enough. Is that what you're saying?
Yes, that is correct. A municipality would be running into a 14th Amendment failure to apply the law equally to all citizens if it denied HS Robin Hood water and sewer, but everybody else got it.
Okay.
Mr. Durham, sorry. It looked like you had a
Yeah, I was
question.
gonna ask a question. So was that determination made by so you've reviewed the application, right? And as we've submitted, and we see we see this approval for the water to the extent that it's required for this process? Not as described here?
Do you have a page you can point me to?
I don't in the application. I'd have to look back and see in the town's requirements. That's on that.
This might be a
MD list.
very,
Are you referring to the checklist?
Right.
That's.
Is it on the checklist?
You're asking if it's on the checklist? Is that-
Yeah, I don't recall if it was. That's what I was asking.
I think I have that page right here.
Well,
But this is a very, very high-level, broad checklist right here.
This is the application? Is that
You're-
what you got?
He's talking about the Mountain Village checklist, correct, Mr. Duroni?
Yeah, I believe it. I just didn't recall if it was on that checklist as.
That is,
Something that was
it's
already
tab
covered.
12, so it's RD 054, and 055 is the record of, I want to make sure that's what you're discussing too.
I'm glad you're clarifying, because I think he's looking at the
Okay.
application and you're talking about the checklist.
Yeah,
So
that's
we're
right.
looking apples and
This-
oranges.
Yeah.
Is this what you're talking about?
Yeah.
This was a checklist that was not
Yeah.
available. It's called an internal checklist. It was not in the ordinance. So the civil engineer had no access to this in any form until it was later asked for and volunteered.
Testimony about what the civil engineer had access to without any personal knowledge established as a foundation to give that type of testimony in this case. I don't think it's appropriate and ask them to answer the stricken.
Okay, sustained, can that be stricken? And can you testify to what your knowledge of this actual case is? Because I agree.
Yes, I can. There are many emails and references in here between Sean Sains and Chris Day, I think it's, where they're asking, what is your checklist? Where is your checklist? What is your checklist? And eventually, at some point, Ms. Eisenhower said, here, use an internal checklist. But the questions were asked. So that's from my knowledge of this case and from reading the record.
And I want to make sure we're answering your question. Your question too, Mr. Duroni, seems to be, is this requirement that's in 5437 listed anywhere on the checklist that is 054 through 055? So if you look at RD 054 and 055, Mr. Duroni's just asking if this requirement's on the checklist.
Actually, I don't see anything related to public utilities.
That's right.
Mr. Darney, does that answer your question?
Yeah, I was just trying to see where the approval for the water is listed in the ordinance. I'm thinking of a different place, I guess. I'll bring it up if I think of it.
Yes. And to further answer, there's nothing on the zoning compliant compliance permit application either. This is a form that's generated by the town of Woodfin. There's nothing on that I see that asks for water and sewer.
So now moving on to the third provision that Mr. Green relied on, and that's section 54, 318.5. And it's on page 3 as well. And once you get back to there, I know you've been flipping around.
Okay?
Do you see where he references section 54, 318.5?
I do.
Okay, and do you agree that there's an ellipses about halfway in that section?
Yes, I do.
Okay, what's that ellipses signify to you?
It signifies that he was making misrepresentations, and in my opinion, intentional misrepresentations, and I'll be glad to explain.
Hang on, Mr. Terrell, hold on a second, please. Go ahead, Mr. Norr.
My objection, one, that this is speculatory as to what Mr. Green was intending is language in his report. Number two, it is incredibly inflammatory and prejudicial without any foundation being laid prior to giving that opinion about Mr. Green's intent behind it. It is being done solely for the purpose of essentially, I think, prejudicing the board against testimony that it's already received. I would ask that it be stricken. And also, I think, I'd ask that it be stricken.
So the motion is going to be, or the objection could be sustained, and they can have the last response stricken from the record. And I'm going to ask the witness to answer the questions from the attorney as he asked them, and not, how can I say this, wander. I'm trying to think of a good way of, not your opinion, but what.
He asked me what the words were.
Yes.
Is it fair to say that an ellipsis signifies that something is missing from that section?
That is fair to say, and you can do it, and I can do it, and Mr. Norr can do it when we're in court, in our legal briefs, but there are limits.
Okay, so let's take a look, though, at that entire provision, starting with the first sentence. And it's up on the screen, or if you have it in front of you, that's fine. It said, "The procedure for approvals of group development plans shall include the submission of a design plan showing the proposed layout, including the location of buildings, driveways, street parking spaces, and recreation areas to the Planning and Zoning Board of Adjustment for study prior to final approval." Did I read that correctly?
You read that correctly.
Okay, so is there anything in that sentence that says HS Robin Hood is required to provide something at the time it submits its zoning compliance permit application?
There is not. The ellipses omitted that language.
And then it goes on to say, where applicable, the design plan package shall include approvals for the proposed sanitary sewer and water distribution systems from the appropriate state and local agencies. Did I read that correctly?
You read that correctly.
Okay, and again, is there anything in that sentence that says HS Robin Hood was required to provide the information at the time it submitted its zoning compliance permit application?
Not in the way it is written in toto, but you asked me what was in his report. And omitting those words that are right next to each other changed both the application and the meaning. Now, I can avoid getting into what the intentions were, but I don't know how that could have been missed. They are so close together, and the impact of omitting those words is incredible.
When you read it in total, what is your interpretation based on your experience?
Well, first of all, you read it the way it is intended, you read it as it has been written, and it says you do it prior to final approval, which means you do it at the construction drawing stage. You don't do it at the beginning, you do it at the end stage. And that's what I was talking about at the very beginning. And then where applicable, that's when we turn to the planning professionals like Ms. Tuck, and to determine, is this a situation where it's applicable?
Go ahead.
Am I wrong, or are we not dealing with a group development? I thought it wasn't a group development. I thought it was one building. I don't understand. I'm sorry, I'm asking him. I'm looking at you, I'm sorry.
I have read your ordinance. It is not a group development, and I can, if the time comes that he asks me those questions, I can
Yeah.
explain why.
So it's not.
It is not.
So
But-
why
but-
are we looking at this?
But he was asking me a question about the reasons Mr. Green gave as to why it was an incomplete application. And I'm saying, well, it doesn't apply.
Okay, okay.
And again, to clarify, we are looking at this because this is one of the positions that the petitioners have asserted in their case, correct?
Yes, that is correct.
Gotcha.
Okay. So is it your professional opinion that section 54-318-5 is inapplicable for purposes of determining whether HS Robin Hood submitted its zoning compliance permit application on May 17th, 2021?
That is my professional opinion, but there are other reasons that go into the fact that it's not a group development.
And we'll
So my question stemmed originally that I was trying to look for in here, but it's really, it may be this statement in here where it says, where applicable, the design package shall include approvals for the proposed water and sewer, or sanitary sewer and water distribution systems from the appropriate state and local agencies. So not a full, plan about the pipes and the locations of the whole system.
Right.
But just the approval for the sanitary sewer and water distribution. So wouldn't the approval still be required, though?
Ultimately,
Full design, right?
Yes, ultimately, you would have to have some type of approvals that say this is the right size pipe, things like that. It's buried at the appropriate depth. There's for sewage to run downhill, it's at the appropriate depth of all the pipes. But that's not at the beginning, just.
Yeah, and I wasn't talking about the design of the pipe size and the depth, just the plan, just the
Yes.
approval for a sewer and water system.
That is correct. But in an ordinance, you can't, if it says where applicable, you can't hold somebody to having failed to bring it because you have not said this is required. You have created a broad category without putting somebody on notice.
Thanks.
So based on your review of 5411, 5437, and 54318, is it accurate to say that none of those provisions required HS Robin Hood to provide water or sanitary approvals or permits at the time it submitted its zoning compliance permit application on May 17th, 2021?
Yeah, that is my opinion, and they're also outside Article 2.
Okay. So that deals with the water and sewer and sanitary permits that Mr. Green discussed and that petitioners are addressing. I want to now move to the landscape compliance plan and the architectural guidelines as well. But let's start with the landscape compliance plan. The petitioners and Mr. Green cited to section 54-249E8 for the proposition that HS Robin Hood owner was required to submit a landscape compliance plan prepared by a licensed landscape architect at the same time it submitted its zoning compliance permit application. Have you reviewed section 54-249E8?
Yes, I have, if you'll give me a chance to turn to it. Yes. I'm here.
And based on your review of that provision, is there anything that says HS Robin Hood was required to provide a landscape compliance plan prepared by a licensed landscape architect at the same time it provided its zoning compliance permit application?
Yes, there's the absence of that language in there, for number one. And number two, this is not an Article 2 requirement.
So I just want to make sure I understood your answer correctly. Was HS Robin Hood required to provide a zoning or landscape compliance plan at the same time it submitted its zoning compliance permit application?
It was not.
Okay. And what are the reasons why it was not?
Because this section, number one, is outside Article 2. Even if it were inside Article 2, it does not say you submit this at the time of your zoning compliance application. Now, you can't get away with not submitting it at some point But this is part of that give and take process. Your site plans change. Your buildings may shift. This happens all the time. So your detailed site plan, your detailed landscaping typically is very late in the process.
And are you familiar with Ms. Eisenhower's testimony that the planning board could actually conditionally approve a zoning compliance permit application subject to an application providing a landscape compliance plan prior to issuance of a permit?
Yes, I'm familiar with that.
Okay, and is her testimony consistent with the language of the ordinance?
It is.
Okay, and are you familiar with Ms. Tuck's testimony that the planning board could conditionally approve a zoning compliance permit application subject to an applicant providing a landscape compliance plan prior to the issuance of the permit?
I'm not familiar with that because I have seen the transcript. We spoke very briefly, and I have heard you say it, just so you know where my information is from.
Would it,
I'll object and ask that the response be stricken, that his testimony was provided based on his conversations with council, based on his versus his personal knowledge or review.
I'll rephrase the question.
Sustain and please, yes.
To the extent Ms. Tuck testified that the planning board could conditionally approve a zoning compliance permit application subject to an applicant providing a landscape compliance plan prior to issuance of a permit, would that testimony be consistent with the language of 54-249E8?
Yes, it is.
Is that, the planning board decision would be based upon that as a stipulation? What do we call those?
A condition.
Do the same things apply to the application in general, if it's not in front of a planning board, that they need to submit, the landscape plan, complete at a later date?
Yes, my understanding now is that the landscape plan comes in with the master plan. The master plan is reviewed by the planning board under your ordinance. And so the planning board would, at a later point, be making those determinations as to whether it complies with the width of the planting yard, the types of vegetation, things like that.
Before they give a permit, before they issue a permit. It
Well,
has to be done.
there are two kinds, or three, well, there are many kinds of permits. When you say a permit,
A permit to continue the project.
I don't read this as being, there's I could be wrong, but an issuance of a permit to continue. You have a zoning compliance permit that says you are in compliance with the ordinance,
Right.
so you can go to the planning board for the entitlements, and they do an administrative review. But then you go through the process later and have all your construction drawings, the sheets that I just described, it can be anywhere from dozens to hundreds of pages, depending upon the project. And that's where you get a variety of construction permits, building permit being probably the most common one that you hear about.
So what
Okay,
about?
I think Ms. Hoffman's question is, this question, is that all this documentation would have to be submitted prior to the issuance of a zoning permit. I believe that's what we've been talking
We're
about.
not changing zoning.
Yeah, but I thought we called it,
Well-
thought it was known as a zoning permit.
It is, that's what it's called.
Yeah, is that
It's,
what
yeah, it's called the zoning compliance application permit, but I think,
There's actually a place in the ordinance where it refers to it as a zoning permit, so there is some ambiguity in the ordinance. Now, that reference to a zoning permit is not in Article 2, but a zoning permit can mean, and often does mean, something else. And
Right, that's what I would think.
yeah. A zoning permit is typically the last thing that you give to say, everything is good to go, now bring me your plans for a building permit.
Right.
Well, I believe that's the question you're asking.
And then we can rezone it?
No, you would have rezoned it already.
Okay.
You don't issue a zoning permit until
Okay.
zoning is properly in place and the uses are comply with that district, things like that.
Okay. Okay.
just want to make sure, are there any other further questions? Okay. So, just to bring us back full circle, in your professional opinion, is a landscape compliance plan necessary for purposes of determining whether HS Robin Hood properly submitted its zoning compliance permit application under Woodfin's?
It is my opinion they did not have to present that at the zoning compliance stage.
Right. They also, petitioners have talked about the architectural guidelines. So let's talk about that real quick. That's in section 54-249E12.
I'm looking at that right now.
I think we have it up on the screen, and that says, applications and master plans for mountain villages shall be accompanied by urban and architectural design guidelines to be prepared by the applicant. Did I read that correctly?
You read that correctly.
Okay, what is the ordinance talking about when it's referencing the applications in this provision?
These are the applications for construction permits. Different jurisdictions call them different things, but the statutes consolidated some terms 4 years ago to call them construction permits, and you see that more often.
So it's not discussing a zoning compliance permit application?
It is not. This is the stage of bringing in your construction drawings, the details, the large sheets with many pages.
So is it your professional opinion that this provision does not impose any obligation on HS Robin Hood for purposes of triggering the permit choice provisions?
That is my opinion, and for the additional reason that it's not in Article 2.
I have a question about this. So this is the specific to mountain villages, but he is, or you're, I'm sorry, you were saying that it's not in Article 2. Is the, explain, I'm misunderstanding the mountain village portion then, and the Article 2 that you're referring to.
Okay.
So is this is applicable because it's Mountain Village, correct?
It is applicable for Mountain Village, but it's applicable at a later stage in the process. If you're in the Mountain Village district and you're doing something that's consistent with the uses in a Mountain Village district, you cannot avoid going through this, but you don't do it at the stage of zoning compliance. This is late stage right here, and partly because of what's being asked, but also by the context of Article 2 says, you show us everything that's in this article. And they are high level and broad, and they don't go into the granular detail that is in 54-249, subparagraph 12.
But it does say that the application and master plans shall be accompanied by the architectural design, correct? So that there's some degree of this, right? Not
Eventually,
complete,
you will have to have that, yes.
And again, is there a difference between the application and master plan that they're discussing here in the zoning compliance permit application in the site plan that was submitted?
There is a difference. The zoning compliance does not list all this. The zoning compliance section has very specific items that are listed. And it is HS Robin Hood's duty to read that section and to comply with that section to the extent that it's applicable. But it is not required at that stage to jump through every single thing in the ordinance that's not in Article 2.
And we're actually about to get into what you call the zoning compliance section 5435. But before I get into that, it does set forth a few guidelines, I guess 3 specific guidelines in this instance, correct? The 1, 2, 3?
Yes?
Okay, and if we turn to the May 2021 site plan up, RD 005.
Are you pulling that up?
I think, yeah, she's pulling it up. It's in the record.
I have seen that site plan, and yes, those appear to be on it.
I would just direct the board to, I guess, the RD 005. There we go. It's also up on the board. And I think you just testified to this, Mr. Terrell, but would you agree that those three specific provisions, though, were nonetheless listed on the May 2021 site plan?
Yes, they are listed in a box in the lower right to the left of the bar where it says preliminary not released for construction.
So was
Leading questions are not appropriate in this context. Just at this point, and going forward, you should be asking the question what his opinion is, not providing that opinion for him and then asking him whether he agrees. I'm not asking that prior answers be stricken, but I'm asking going forward that typical question and answer be used versus the use of leading questions on direct examination.
I've been asking, is it his opinion, is it not? This was a specific instance, I'll let you talk. This was a specific instance, though, where he actually already said, I've reviewed the record, it's on there. So I was just restating what he already testified to. It's appropriate to address it and ask it in that way.
And I'm just asking going forward that we stop with the leading questions and giving the expert their opinion and then asking whether they agree or not, instead of ask what the opinion is.
I haven't been doing that.
All right, sustained, and we're going to ask the question and ask their opinion going forward, please.
Okay, if we turn to RD 014, are those same guidelines on the October 2021 site plan?
Yes, they are.
Okay, if we turn to RD 025,
025.
025. And if you get there, are those guidelines on that site plan?
Yes, they're in the same place.
Okay,
Which RD is that?
025. If you turn to RD 030, once you get there, I would ask, are those guidelines on that site plan?
Which guidelines are we talking about?
There are guidelines.
Oh, you mean the little blurb that says
yes, it's
front
from-
porch, everything?
Yeah,
Okay.
from
Every time.
54-249,
Gotcha.
subparagraph 12.
Yeah, it appears every time.
That's correct. And yes, this shows them as well.
So would you agree, based on that, with Mr. Green's opinion and the position of the petitioners, that the initial site plan and other site plans did not include those guidelines?
Repeat that, please.
Do you agree with the position in Mr. Green's report that the site plans do not contain those guidelines?
I think factually, that's incorrect. I mean, we're looking at them.
Turning to section now, you've talked about section 5435. Pull that up on the screen, and if you have it in
Tell
front of
me
you as well.
again, which section?
5435.
5435?
Yeah, 54-35. And you've been talking about Article 2 a lot. Is this what you were talking about when you're talking about Article 2?
Yes.
And based on your review of this article and your professional opinion, what's the significance of this article?
This article creates a framework within which an applicant is able to interpret what's required of them to meet their duties under this ordinance. And it's not expansive, it's very simple, and it says, it's basically in 54-35, here's this very small list, and anything else in this article that applies. And the article is about 3 pages. My interpretation is totally consistent with how our state Supreme Court interprets the different articles.
Yeah, well,
Opinion on how the Supreme Court would.
It's just talking about,
Sustained, and if the witness would just answer attorney's questions and not present your own.
it was a further answer. He asked me my opinion, and I was telling him that it was based in law.
And my objection was him opining about what the Supreme Court would say about his opinion or
I-
consistency therewith. I think you sustained it, so.
Yes, sustained.
Mr. Chairman, I was describing past cases, it was not speculation on what a court would do.
is there any language in this article where it says that a landscape compliance plan must be submitted contemporaneously with the zoning compliance permit application?
In this section,
Correct.
ask that again.
Is there any language in this section that says a zoning or a landscape compliance plan must be provided with a zoning compliance permit application?
I don't see it.
Is there any language in this section that says HS Robin Hood had to submit approvals for sanitary sewer and water distribution systems contemporaneously with its zoning compliance permit application?
There is not.
I have a question. The application shall include such other information as may be necessary to determine conformance with and provide for the enforcement of what article? This article? I don't
Article 2,
understand.
this is in, the zoning code is divided into articles, and this is
Okay.
Article 2 right here. You have the
This is
definitions in
Article
Article 1, things like that.
Okay.
I got distracted from your question. I'm not sure if I answered.
You answered. I think Ms. Hoffman's still asking.
Yeah, because it says in Article 2, building permit required, health department approval? Is this what's required as in Article 2, which we just read? Is it too late? Am I really, can I even talk?
And I think what Ms.
What I'm
Hoffman.
trying to say is, it says that such other information as may be necessary to determine conformance, and in this article, and you said it's Article 2, and then the Article 2 lists a whole lot of stuff that needs to be complied with.
That is correct. But if it does not list, what you have to do, this is part of that process that I said was a give and take. For example, I have a project and I go sit down with Ms. Took, and she will say, oh, by the way, there are issues over there related to boundary disputes, or there are some specific issues that we need you to bring back information on. Maybe the pressure in the hydrant system, something that she specifically knows about. She would then ask the engineer or whoever's representing the project to bring back that information. And that's legitimate if there's something specific, unique to that site. But you can't say in a broad brush, any and all information that might be relevant and leave a developer guessing as to what that is.
I understand what you're saying, and that's a crappy position, lousy position to be a developer in a, but it does say that. It says that everything, it looks to me like everything that's listed under Article 2 needs to be complied with. Doesn't it say that?
Yeah, maybe I could ask the questions
Yeah.
another way. I think she's wondering whether 5435 and 5437 that we looked at earlier are included under Article 2. And it looks like,
Yeah.
Yeah, 5437 is in Article 2.
Okay.
But 5437 opens with the phrase, where applicable, And you,
Well, what the hell, what's this? Why are they even?
See my book.
um,
This is opinion.
but so we're still go back to, it would be Ms. Took's prerogative and is within the statutory power she's been given as a zoning administrator to ask for more information if she identifies something, but she would have to say that in the early meetings, rather than saying it's a blank slate. You figure it out and we'll tell you whether you met the bar or not. So at some point, it's going to be, you're trying to put a shoe on a running horse, and that doesn't work.
And I think, to clarify too, Ms. Hoffman has referred to, like, there's a building permit required section 50, but if you look at that section, 5436, is that something that applies to the zoning compliance permit application?
It does not.
If we read that, it says, upon receiving a zoning compliance permit, a building permit shall be obtained from the county building inspection officer for the construction or alteration of any building, structure, or mobile home, correct?
Are you reading in 35?
Yeah, 54-36.
Or 36?
Oh, okay. Okay, so it's
Okay,
not
yeah,
at the
and-
time of the.
Yeah, that's right.
When the permit is,
That is correct. This is at the time before you pull out your hammer and nails, you have to have a building permit. You don't have a building permit to go through entitlement.
And is that talking about the process you discussed at the beginning of this case?
Yes,
Or of your testimony, I thought?
yes.
Yeah. So based on your review of Woodfin's code and the application and site plans that are in the record of decision, did HS Robin Hood submit its application on May 17th, 2021 for purposes of triggering permit choice?
Yes, it did.
To the leading question, I asked this, he asked his opinion on what his opinion is about fill in the blank, but he has again inserted the opinion and asked him to, if he agrees.
I don't know how his task did.
So I guess your objection is that he's asking the question and asked if he agrees to his statement.
That's right, and that's called a leading question, it's not a
Okay.
direct examination. He's
That
supposed
was-
to ask the expert what his opinions are, not give the opinions to him and ask if he agrees with them.
I didn't ask if he agrees. I said, did HS Robin Hood do X, Y, Z? It's a yes or no. That's not a leading question.
That's correct.
Overruled. Let's let this one go, but going forward, let's just let the witness answer the question, please.
Based on your review of Woodfin's code and your review of the record of decision, in your opinion, did HS Robin Hood submit an zoning compliance permit application on May 17th, 2021 for purposes of triggering permit choice rules?
I'll object to the speculatory nature, and he's asking what their intent was, not what they did.
He didn't ask intent.
That has nothing to do with intent. We sat and listened to him
For the
ask
purposes-
two witnesses these
He
questions.
said, for the purposes of filling the blank, what were they doing? That's speculating as to their purpose for doing something. That is not, did they or did they not do something? It's speculatory, and that's the.
They spent 2 or 3 days on this stuff with their witnesses. We are absolutely entitled to ask these questions of our witnesses. If we aren't, we are not getting a fair shake.
Ask the board. So my opinion is we should let this be heard, but I was asking your opinion, so we should overrule the objection and let it be heard. Do we agree?
I think that, I'm hearing the objection with the wording, and if he words it slightly different, instead of, I understand the leading question issue, right? And then this is for purposes of. If he's not asking him for purposes of, if he's just asking, if, in his opinion, do they do something, yes or no, then that's really, that's different. So I think that's where the hangup was, is the way that you're wording it.
The issue is they've had experts testify that he did not properly submit an application for purposes of permit choice. He is the expert here to testify on that issue.
I'm going to ask him for some legal advice.
We need to rule on the
I
objection.
know. So we should overrule.
I think so.
Mr. Noor, we're going to overrule on this objection, but I'm going to say but. We understand what the concerns are, correct?
Understood. Yeah, I'm doing.
So we can keep
yeah,
this moving
try-
along. Please.
Based on your review of Woodfin's code and the record of decision, is it your professional opinion that HS Robinhood submitted its application on May 17th, 2021 for purposes of triggering permit choice rules?
Absolutely, yes, they did.
So we've now gotten through the petitioner's first argument that the, sorry, I'm just going to let her.
Yeah, sorry, just 1 second. Mr. Foreman, while we're taking a little break, what is your projected time frame? Just rough estimate. Just trying to get a handle where we're going tonight.
20, 30 minutes.
Okay.
Hopefully.
That's fine. Please continue.
All right, so this brings us to the second opinion that they've asserted in this case, and that is that the application was discontinued under North Carolina General Statute, Section 143, 755B. So if we could pull up 143, 755B1, I apologize. And before I start asking about that, I just want to ask Mr. Terrell if you are familiar with Section 143, 755B1.
I'm very familiar with both the history and the application.
How so?
The permit choice rule has only been around for maybe 15 years, but maybe not even that long, 10 years. But the permit choice rule was something promoted by the North Carolina home builders, but it came out of one of the cases that you cited in your brief, the Gaston County case. There was a later case, it was my case, Woodleaf, that came along. And this was when there was a movement to protect people who had vested their rights in some way. And it gave them the opportunity, and this was the argument the home builders made, is that a developer should have the opportunity to choose between the law that they applied under and the law that has been changed to. There were, and it's maybe too much, but there were two cases that came out the same day in 2005 that were also prompting it, that basically said this, and that it came out of the Woodleaf and the Robbins case.
The question was, are you familiar with this? And now,
I said how so, actually.
He said, he asked me how I was.
forgive me, I forgot how so.
Okay.
As you went on, so I withdraw the objection.
Okay. Continue, Mr. Terrell.
But importantly, this is a long way of getting to, this talks about something being placed on hold. That is not a term that I have ever heard in the industry until somebody, presumably at bill drafting, put it in the statute. But it's not something that I have ever used in all my cases. But it is here now, it's a statutory creation.
Okay, and before we get into the hold, I want to actually address the initial argument that they're asserting. Is that the plans provided on October, this is on page 5 of Mr. Green's report. It says the plans provided on October 13th, 2021 did not provide the required information requested in Ms. Eisenhower's May 17th, 2021 email. And my question to you is, based on your review of the record and in your professional opinion, do you agree with Mr. Green's position?
Mr. Green is absolutely wrong.
How so?
There was a later, 5 months later, there was a further plans that were submitted, and those plans had, everything she had asked for was in those plans.
Okay. Now I want to get to their argument that it was placed on hold. According to Mr. Green's report on page 5, he says HS Robinhood placed the application on hold on May 18th, 2021 through the email of Mr. Day at CDC to Ms. Eisenhower, where he requested not to be placed on the June 2021 agenda. I don't know, do we have that email?
I have read the email. It says nothing about being placed on hold.
And I was going to ask, based on your review of the record and your professional experience, do you agree with Mr. Green that that is the act of placing the application on hold?
Your question is in my experience. 4 or 5 times a year, I will ask for something to be placed on a later agenda or an earlier agenda, depending upon what the client's needs are. But being asked to be placed on a different agenda, sometimes to accommodate my schedule, but that to be in another place, it has nothing to do with something being put on hold. It's an agenda issue.
All right, that brings us to another opinion of Mr. Green. In his report, he states that it is his professional opinion that the October 13th, 2021 site plan should have been considered a new request because it is substantially different than that depicted on the May 17th, 2021 submittal, and that's on page 7 of Mr. Green's report.
I saw that.
Do you agree with that statement?
In North Carolina, a substantially different site plan does not negate your rights from the time of submittal. The Woodleaf case that I argued before the North Carolina Court of Appeals very clearly said that. The Robbins case that came out the same day in 2005 said that. The Robbins case went to the Supreme Court. Supreme Court affirmed and emphasized that there is a process. It's a give and take. You cited, and it's a good case, the Northwest Financial Services versus Gaston County. That's probably the grandfather case, and that site plan went through numerous revisions. That was for a trailer park, but it was what the courts keep saying is part of the normal give and take.
Okay, and if you could bring up section 160D 108A. And this is a permit choice statute. You have that in front of you, Mr.
I'm looking at it.
Okay, does this provision contemplate the potential for revisions to site plans?
Yes, it does.
Okay, and can you tell the board where it does that?
Well, it anticipates a process whereby several things have to happen in sequence. You cannot change a zoning amendment overnight. Now, you can pass a moratorium overnight, but the typical process by which you would do a zoning amendment that would affect something in application is 60 days. That's the minimum. But typically these things start with, again, I'll point to Ms. Tuck, they start with her staff, they start with people studying it, it eventually goes to some type of public review, a citizens group, then it gets to a planning board, it may or may not go to the next elected body. So you can't even get into this until you know that there is a long extended process. And you're caught in that gap.
Okay, and if we could pull up section 143, 755 as well. Do you have both, or is it? But my question to you, Mr. Terrell, if you have the full section in front of you, 143, 755, which again is permit choice, does that provision expressly contemplate the potential for revisions to site plans?
Well, I don't have it in front of me, except by reference to that in 160D-108. But yes, the permit choice anticipates that there's a longer period of time during which the law has changed, while you were negotiating with staff during that normal give and take.
And on page 7 of Mr. Green's report, he also states that the impacts of short-term rentals are different than those of a long-term residential use and must be considered differently. This is another justification for treating the October 13th, 2021 application as a separate and distinct from the May 2021 application. Do you agree with that opinion of Mr. Green?
Mr. Green expressed a policy and an opinion. It has nothing to do with what the law says.
Again, and on the same page, Mr. Green states that the development plan submitted to the town on August 8th, 2022 is significantly different than the plan submitted previously and should have been considered as a new submittal subject to the rules and regulations in effect at the time, August 22nd, application was complete. Do you agree with that statement by Mr. Green?
Not only do I disagree, but our Supreme Court disagrees.
I will object.
That's the Gaston case.
I will object to classification. The Supreme Court disagrees with Mr. Green's opinion. There's been no ruling on this. We're in front of board adjustment. That has to be stricken.
Now, may I explain and say it differently?
Well, I'm going to rule on that and say sustain. We'll strike the last response,
Okay.
and if you want to ask the question differently.
Why do you disagree with Mr. Green?
Because our Supreme Court in the Gaston County case, Northwest Financial Services versus Gaston County, Woodley versus Mecklenburg, Robbins versus Hillsborough, have said continuously, but mainly the Gaston case, major revisions of a site plan are still part of the normal give and take between an applicant and a planning staff.
Moving on, I know we're getting fairly late, so I want to turn to page 8 of Mr. Green's report. And he states that the proposed short-term rentals are not multifamily dwellings under the town zoning ordinance. And in support of that position, he states that dwellings must be used exclusively as a residence and not include boarding houses, lodging houses, motels, and hotels. He then goes on to say that the short-term rentals are consistent with the definition of a hotel. Do you agree with that opinion?
His opinion is inconsistent with statute.
And let's actually turn, I think, to Article 30 of the ordinance and the definition of short-term rental. So again, is this the definition of short-term rental? Is this definition of short-term rental included in the version of the ordinance that was in effect on May 17th, 2021?
Yes, that's the version that was in effect in 2021.
And if we turn back to the definition of dwelling in 54-5, do you see the term short-term rental included in the exclusions to the definition of dwelling?
You're talking about CD 54.7.
Sorry, 54-5, it's up on the screen as well. It's the definition of dwelling.
Yeah, okay, I'm looking at that. I was looking for the page
Okay.
reference. Dwelling means a detached building designed or used exclusively as a residence or a sleeping place, but does not include, but no, short-term rental is not one of the exclusions.
In your professional opinion, what does that signify to you?
It signifies that there was by using standard canons of construction, it means that when you list the things that are excluded, anything not in that list is not excluded. This is a standard canon of construction.
Can I ask a question?
Sure.
This came out of the planning, yes?
What's on the screen?
Did that the definition come out of the planner's dictionary?
This is directly from Woodfin's zoning ordinance.
Woodfin zoning ordinance,
Yes.
okay. Well, what I was going to ask you was, it seems like, again, we're talking about short-term rentals as opposed to hotels and motels. Is there anywhere, do you know anything about the planner's dictionary? No. Is there anywhere in this or in the ordinance, the Woodfin ordinance, that says, that refers to short-term rental? Anywhere,
Yes.
anywhere?
Yes,
Where?
short-term rentals are
Oh,
in
good.
chapter 30, and that's what he was just referring to.
Okay.
He just mentioned a while ago. But
So again, just to answer on the
Right.
screen, this is the definition of short-term rental included in Woodfin's ordinance, correct?
that's correct.
Okay, and
Okay, so it is
But-
included in the
You have
ordinance?
to ask.
Yes.
Oh, I'm sorry, it
That's
is
correct.
included in the
But,
ordinance?
but there are, you're really, the question you're asking is, what is the applicable
Wait a
definition
second,
of
wait a
the
second.
thing?
You are supposed to ask him the question.
Okay.
I'm
So
sorry.
don't answer his
The
question.
question I'm asking is, is it a common term to say short-term rental? Or are we not using it very much, or does it appear in other areas? Or is it, you know what I'm saying? What I'm trying to say is.
Let me try to answer.
Good.
Let me try to answer. Short-term rental is a colloquial term.
Yeah.
That is not, there is no precise definition. There are different, some people refer to them as Airbnb, which is, we all know is a specific company. But short-term rentals is becoming the most common of those terms. Now, the question is, where do you categorize a short-term rental in the definition of what have in front of us right here? And the only way you can categorize it is by looking at the North Carolina statute.
Right.
The new statute, 160D, codified a lot of definitions. Municipalities and counties don't have the freedom to create their own definitions. Woodfin only has the zoning powers that the state of North Carolina specifically says it has, and the state statute in 160D, it's 102, paragraph 15, defines what a dwelling is. It does not mention short-term rentals. It says it's any building, structure, manufactured home, or mobile home, or part thereof, used and occupied for human habitation. That's all it is. Used and occupied for human habitation, or intended to be used, therefore. So, to the extent that Woodfin has a definition that doesn't comply with that definition, this definition that I'm reading from the statute would control. It's called a preemption issue. You don't have the authority to enact an ordinance that is contrary to a statutory term. You're not the sovereign, the state of North Carolina is.
So can I, just to confirm that I heard the correct answer to the question,
Yeah.
state is the higher power of authority, so they overrule Woodfin.
That's right.
Okay.
And Mr. Terrell, is this the provision you were referring to in the general statute?
Yes, that is the provision.
And was it your testimony that to the extent Woodfin's ordinance is inconsistent, this definition controls?
That's correct.
Okay, does this definition exclude short-term rentals from the definition of a dwelling?
It does not.
So does Woodfin's ordinance exclude short-term rentals from its definition of a dwelling?
I did not see the exclusion in that. It listed 4 or 5 things, but not short-term rentals.
All right, moving on, I want to go to page 8 of Mr. Green's report. He says, the October 18th development plan depicts 3 multifamily buildings connected by what appeared to be breezeways with 110 units to be used as short-term rentals. I want to address that, a couple items there.
Excuse me, I was shifting
Yep.
books here. Tell me again where you're looking.
Page 8 of Mr. Green's report.
How many paragraphs down? Okay.
It's right under the October 2022 application.
I see that.
My first question is, did Ms. Tuck's September 30th, 2022 determination address the October 18th, 2022 site plan?
Yes, it did.
Sorry, I just want to make sure. Did Ms. Tuck's September 30th determination address the October 18th, 2022 site plan?
I don't recall that it did, but the record is whatever the record is.
And I guess what I'm asking, the October 18th, 2022 site plan came after Ms. Tuck actually issued her. Did this October 18th, 2022 site plan come
Yes,
after Ms. Tuck's
the
determination?
question is, yes, is October after September? Yes.
And going back to Mr. Green's position that the plan depicts 3 multifamily buildings, do you agree with that opinion?
I do not,
Why not?
for 3 reasons. Interesting, I think I heard Ms. Tuck say something about that in the one of the clips that were being played. But when the architect says that under the building code, this is a building, then it is a building. This is the architect interpreting the building code. And so we rely upon people who come in and put their seal on that. It's also because it looks to me like there's a common floor and a common roof. Now, there's nothing that I've ever seen in a statute or case that says a breezeway prevents them from being a common building. But I will tell you this, there are no setbacks. They cannot be separate buildings, because if they were separate buildings, there would have to be setbacks between them, and there are none. Now, I looked at what the setback provision was in the code for Mountain Village, and it defers to what is called the county fire code. I think it should say the state fire code, because counties aren't free to develop their own specific unique codes. But that means that it would be at least 20 feet. It could be 25. I would have to research that, but I believe it's 20 feet.
And during that testimony, you mentioned the building code. What were you referring to?
Just saying, I was referencing the fire code, and I was actually referencing 54 dash, I think it was 249.
You're going more specific, I guess, than I'm asking. Are you referencing the North Carolina building code?
North Carolina building code, yes.
And is that based on the international building code?
It is based on the international building code. The counties don't have their own building codes, only the state has. And the reference to the county fire code is the same thing.
All right. Are you familiar with the statutory time period in which a person or entity has to file an appeal of a determination made by a zoning administrator under North Carolina law?
I actually participated in drafting that.
So the answer, I guess,
Answer is yes.
Yes. Okay. Do you, based on your experience in drafting that, what's the reason for imposing that time period?
I'll object to speculation that the legislature had in imposing a time period for filing appeals. I don't think the witness has any personal knowledge or.
I can tell what the law is.
That opinion.
Sustained, and rephrase the question that the witness can answer.
What is the law with respect to appealing determinations made by a zoning administrator?
The law, as stated in many cases and as stated in the statute, is that you have a trigger point by which you have actual or constructive notice. Now, this was the change that we made when we rewrote the Board of Adjustment statute in 2013. Prior to that time, it was vague, and you had municipalities all over the place that gave you 10 days after a decision was made. And in fact, this was one of my personal beefs. That's not fair to a neighbor. You can't get a lawyer on the phone in 10 days. So we we extended that to 30 days to be consistent with North Carolina law on a lot of things, and 30 days is a very common for certain types of permits. And it has a trigger point where you have actual or constructive notice of something that you think was incorrect, and then you have a 30-day period to appeal.
And if you could turn to RD 079 in the record.
I'm sorry if I have to keep saying.
And Josh, I'm just looking at time.
Got like 3 more questions.
Okay.
I'm holding to his 20-minute, 30-minute.
Okay.
I have skipped some to try and keep within.
Thank you.
You said RD?
079. Mr. Terrell, do you recognize this document based on your review of the record?
Yes, I do.
Okay, can you tell the board what it is?
This is Ms. Eisenhower, who was the planning director at at the time who apparently is changing a position, but she said upon closer review of our records, we're revising the town's position regarding the status of the permit application. And then she says, to summarize, we agree the application was not placed on hold before February 11, 2022. As a result, the application will remain valid at least until August 11, 2022.
And the petitioners in this case are claiming that this determination has no relevance to their claim that the zoning compliance permit application was not submitted under section 143-755. Based on your review of the record and your professional experience, do you agree with that position?
I'll get to this question on a number of different grounds. One, this is not the subject of this appeal. Okay, it's not one of the three things that Mr. Portnoy pointed out were the subject of the appeal in his opening argument. We've talked about this on numerous occasions, so it's irrelevant to this board's decision. Essentially what he's trying to get his witness to give to the board is an opinion about whether we missed their argument, that we missed an appeal that's not even what this board's being asked to rule on. So I would ask that it object to it as being irrelevant and request that.
If I could respond, I struggle to see how this isn't relevant, and he says this isn't the issue in the appeal. Their arguments in this appeal are specifically the application was not properly submitted for triggering permit choice. That's exactly what this is relating to, so I'm just struggling to see how it's not relevant.
That's not our argument at all. As we've made it very clear, we've been talking about specific timelines that have nothing to do with this letter right here. That Ms. Eisenhower testified to had nothing to do with this letter right here. And again, it's irrelevant to this board's job, which is Ms. Tuck's determination on the three things in her September 2022 letter. It's entirely irrelevant.
It goes to the heart of their arguments in this case.
Do we want to hear it and take it? Use our
I
discretion.
wonder why it's in the record of decision if it's irrelevant.
And you can give the answer to that question, some weight, none, no weight, or
Okay.
a lot of weight. You all can.
We're going to overrule the fact that it is in the record of, the letter was put in the record of decision. So it is evidence, so we'll let it, Mr. Portnoy, continue.
And my question was, do you agree with the petitioner's position that this letter is irrelevant to the claim they're asserting in this case that the zoning compliance permit application was not submitted under 143-755?
I do not. I think this does go to the core. I mean, I'm reading this as a third party, looking at it with fresh eyes. I haven't been living this case. I have trouble seeing this as anything but what it is a statement by someone with authority to interpret what's before her, and it's something that their case is challenging.
I have no further questions. Well, I'd actually like to talk with my client real quick, but I believe that's all the questions right now I have. We have no further questions at this time.
And I would suspect, I was going to say that you would want to, John, go ahead. Say what you're going to say. I don't want to say anything for you.
I have a few questions that you'd like.
That's fine.
My only request is that I know that under, just basically process principles, we'd be entitled to have Mr. Carroll back here next week, but I'd just ask that the chair go ahead and issue a subpoena for the 22nd for Mr. Carroll to be here.
I'm teaching a class in Duke that day at, it's at 3:45.
So, Mr. Noor, are you prepared to ask questions, or you are not prepared to ask your questions tonight?
If you want to keep going, I am ready to start asking questions, but I think you're signaling to me that you want to be done tonight. My question, my request is that a subpoena be issued for Mr. Carroll to be here on the 22nd, which was the next day set aside for this just so that he's here and then I'm able to ask my questions.
All right, and question is, Mr. Henning, are you going to have questions, do you believe?
The town is not planning to cross-examine.
I'm sorry?
The town is not planning to cross-examine.
Okay. So the question is, I'm brain dead at this point.
I'm just requesting a subpoena be issued between now and the 22nd.
That's fair enough, because we gave them some latitude to go beyond 9 o'clock. But we're well beyond 9 o'clock, and we've been continuing to go beyond 9 o'clock. So let's try to wrap this up as of now. So we're gonna have to make your witness available on, is it
Could
20?
he, if he said he's out of town, could he do it remotely?
I could, I'll be glad to accept a subpoena, that's not an issue. I had committed to teacher class at Duke that afternoon, it's a renewable energy class. It may be that they can switch things around. I can email or call the professor even this evening to tell him the quandary.
So Mr. Golden, so is it possible, I mean, we did have people earlier in the beginning working with Zoom or whatever. Can the witness testify that? Is that legitimate? We could do that? I mean, you have to swear him in and everything else, so I don't know.
Well, he's already sworn in, so he would still be under oath.
Would Mr. Noor have an objection to it? I mean, let me ask that first, because if you're going to object to it, then forget it.
We allow witnesses to testify remotely beforehand. The complicating factor in this case, at least with this particular witness at this point, is that for cross-examination, I'm going to have to present information that I need him to be able to see. That wasn't the case with the witnesses that came beforehand. And so if he is remote and he cannot see what I'm presenting for me to ask questions about, it impedes my ability to effectively cross-examine this particular witness. I don't in general or in principle have a problem with remote testimony, but I think in this case, the way the witness has showed up in person for part of the testimony, I think he needs to be here in person for the rest of the testimony, and so that I can effectively engage in cross-examination in a way that was not relevant to the prior witnesses.
So are there any other dates other than the 23rd that we can show up at 5 o'clock?
Or 22nd.
So we did have, if I remember correctly, the witnesses, they were reading stuff both ways. We were supplying information on the screen that they were watching as we were both all talking, I believe, like, because Zoom where you share the screen.
And I guess my only request is that if that is not, if we were to do this in a remote fashion, the witness could not view it. Essentially retaining the right to object to proceeding in that way if the witness cannot observe what is being asked of the witness to observe.
Okay.
So that was done beforehand. This will be a much more complicated cross-examination with a lot more information that was provided to the witness than what was previously done for the two witnesses.
And I don't want to create a hardship for Mr. Noor either, so I mean, what legally, how
I
are we
mean,
bound?
I think that the board would have the ability to say, Mr. Terrell can appear virtually. We've allowed it before, but I think the board would take Mr. Noor's objection into consideration in the fact that it is likely to be a more in-depth cross-examination of Mr. Terrell with, as we all know how Mr. Noor presents his case. Sorry, John. How he presents his case, there are a lot of items that he puts up on the screen, asks them to identify and discuss.
Mr. Sword?
Can I just offer a practical comment that the way Mr. Noor is presenting these things from his computer screen is, it is trivial to share that same screen with Mr. Terrell through video conferencing platforms such as Zoom, so that Mr. Terrell will be able to see whatever Mr. Noor has on his screen, and we will be able to see Mr. Terrell give his response.
The trick there, and Mr. Swords is correct, but that was why I asked early on if the town has Zoom. And the town's response is, no, it does not. It only has Microsoft Teams. And so while that is typically not an issue, the Zoom ability to do this is different. And so
Okay.
again, I think he testified in person during part.
Mhm.
I think he should finish that up on the other part. That's my request on behalf of my.
Mr. Golden mentioned, is everyone available on a different day?
Yeah, I think we can find another day.
I was going to ask, like, is it okay if we, reserve the right to cross, redirect, but on the 22nd, if we have other witnesses, to keep this moving along and try and get, let's call those witnesses, and if there's another day that works for the board, Mr. Terrell, Mr. Moore, and everyone.
I think if we could do it the 20th or 21st, we could just limit it to Mr. Terrell's testimony and then have your witnesses come back on the 22nd. I know that puts the town in a bad.
Well, both of those evenings, 21st, excuse me, 20th, 22nd, are slated to be in front of other boards of adjustment.
And in fact, the town of Woodfin's town council will be sitting right up there on the Tuesday, on the 21st.
I'm happy to find another time.
And Monday is officially a holiday, technically. Tuesday, it's not available. Wednesday, Mr. Terrell's not available.
Well-
Thursday, we have another meeting. We have another board meeting that
Could we
day.
do it at
Mr. Chairman,
5?
may I offer a solution? That if I think I might be able to get that class moved. The further issue here is I'm going to be on foreign territory. I don't know where on Duke's campus I could quickly, it's 3:45 to 4:45. I would have to find a place that I could reliably be at somewhere until 9 o'clock. And I don't know how to do that.
So let me ask this question. I am newer to North Carolina. How far is Duke from here?
It's 4 hours, 4.5.
Oh, okay. Okay, so I guess that was my question. Could we be here and have him do his testimony later in the evening? But that's not going to work.
Could look to the following week if we needed to.
And I could let you know very quickly if moving it is possible.
Well, I think that should be our first option, to see if you, Mr. Terrell, could move that meeting at Duke, or your instruction at Duke, so that you could be here next Wednesday at 5 o'clock.
So that would be number one.
Yeah, I'll be back. If we do that, we're fine, we're ready to go.
So
22nd,
option
finding out.
number two, Ms. Gosnell had a good idea. Would everybody be available at 5 PM on the 23rd? Just specifically to finish this one witness. And I know that's a lot on us, but
Two-day mediation that starts the 23rd and goes into the 24th. I have it prior.
And
oh, okay.
I have a hearing.
Trying.
Okay. Never mind.
I guess, so I guess officially, we do not want to hear the end of this witness until you can do, Mr. Noor can cross-examine, is that the right word? In person. So we want to do that. So that's going to be, we're going to do that. Now the question is, do we continue with the 22nd and skip over this witness for right now? Do you have objections to that? I know we've been mixing things up, but this is going to mess up.
I think it's one thing to take a witness and substitute them in and have them completed from beginning to end. I think it's another thing to have half of their testimony and not give me the opportunity to cross-examine that witness and then start with other witnesses. I would ask that I be able to complete this witness and then we move on to others. And I think, again, we can
Fair
start
enough.
with the 22nd, see if that can work.
That's fine.
If not, then we pick another date that we can all come back to.
So
apologize.
the simplest thing, Mr. Terrell, is if you could rearrange your teaching plan.
And I will try.
If, not saying
I don't want to hide behind that or give the impression of hiding behind that. It's an obligation I've had for many months. But, it is a class in renewable energy that has a lot of guest lecturers. And it's possible that I could be switched out with somebody else.
Okay, so in my opinion, and Plan B is we're going to have to just cancel the 22nd. If Mr. Terrell cannot make that date, we're going to have to cancel and reschedule everything if we want to keep the continuity going like we're going. And I agree, we shouldn't be splitting up a witness. We should let them finish out. I mean, does that sound legitimate?
It's going to be in your discretion. It sounds fair. I don't think that we
Everybody agree with
split
that?
up witness testimony.
Because we've been switching things up to make it all go along, but we're going to really get confusing if we split in the middle of a witness, I think. So I guess we're going to have to recess for now, not yet, but we're going to recess to tentatively on the 22nd, I guess. That's where we're going to go, and we'll have to wait to hear back.
Yep, we
How does
can,
that-
we'll set a specific date, time, and place, and it needs to be that date. And if it has to get canceled, then we may just have to have a quorum come here to open that hearing, and then recess it to another specific date and time so that we don't have to re-advertise.
I'm going to assume that tomorrow or the next day doesn't work for everybody? Do we already know?
Literally tomorrow.
Just for a very short period, just to do this witness? I don't know if everybody here on the board is available. You're not, okay. Okay, so who is going to coordinate this? Shannon? Who is the coordinator of all these meetings in the past?
I don't know I don't know that we need to coordinate anything. I think we've got the 22nd set, and when before we recess, we're gonna say we're recessing until a date time, place certain. If Mr. Terrell can't make it here, we are all gonna have to come back, open up, set it for a new date and time, place. But we'll have a week to figure out a new date, because Mr. Terrell is going to provide us some information from Duke as to whether or not they could reschedule your instruction tomorrow sometime, is what I'm hearing you say.
I will text him before I leave the parking lot.
So we're going to have to reconvene even if we're not going to do anything that night?
Correct.
Okay.
We all see that Duke University is the real problem.
Just a reminder, and I know Mr. Chair will accept the subpoena, but there is an actual document that the chair has to issue subpoena for the 22nd, or whichever date comes next. I just haven't had the issue.
Yeah, no issue with that.
So do I have to vote, or I could just
I think
say?
Mr. Golden can prepare that.
No,
for
we'll
you.
prepare it.
Okay, so
and
let's-
sign it.
Mr. Golden, if you would prepare a subpoena for the witness to return on the 22nd,
I actually redrafted that part of the statute as well.
and then if that doesn't work, we'll have to TBD, to be determined what we're doing. So is there any other questions from the board before we close? Any questions from you? Okay. Do the attorneys have any other questions they need to ask before we? Okay.
Mr. Portnoy, anything?
No, not at this time. Yeah, I appreciate the late night.
Okay, so at this point, we are going to recess this meeting until February 22nd, 2023, at 5 PM in this room. That's all. Have a good night.
We're in recess.
Recess.